Good morning. Today is Tuesday, November 13th, 2013. This is a Phase 1 suitability hearing before the Massachusetts Gaming Commission relative to the application of Crossroads, Massachusetts, LLC. My name is Steve Crosby, and I'm the chairman of the commission. I'm joined today by Commissioners Cameron, McHugh, Zuniga, and Stebbins. The entire commission will preside over the hearing and decision on this matter. This is an adjudicatory proceeding which is convened in accordance with 205 CMR 115.04 paragraph 3 and will be conducted pursuant to the formal rules outlined in 801 CMR 1.01, subject to the clarifications contained in 205 CMR 101.03 and Chapter 30A of the General Laws. Fortunately for those clarifications. Before we begin, I'd like to explain the procedural history that led us here as well as the process that will govern this proceeding. Crossroads, Massachusetts, LLC submitted a Phase 1 application to the Commission. The Commission then instructed the Investigations and Enforcement Bureau to commence an investigation into the suitability of the applicant to hold a gaming license in Massachusetts. The Bureau has conducted such an investigation into the qualifications and suitability of the applicant and its qualifiers and has generated an investigative report of its findings, which it submitted to the Commission. A copy of the report was provided to the applicant by the Commission. Based on the report, the Commission has scheduled this proceeding on its own initiative. I see that a number of lawyers are present here today on behalf of the applicant and the Bureau. I will ask that you each please identify yourself and advise the Commission as to whom you will be representing.
Thank you, Mr. Chairman, members of the Commission. My name is Robert Allen. I have a law practice at 300 Washington Street in Brookline. I'm here representing Crossroads. With me today is Jennifer Gilbert from my office and Adam Barnowski from my office. And Jackson?
My name is Jackson King, General Counsel to the Mashantucket Pequot Tribe, representing the Mashantucket Pequot Gaming Enterprise.
My name is John Hickey. I have an office in Philadelphia.
Hi, my name is John Hickey. I have an office in Philadelphia, Pennsylvania. I'm General Counsel for the Potamkin Group, which is an investor in Crossroads.
Okay, everybody on this side? And this?
Good morning, Mr. Chairman, Commissioners. My name is David Mackey from the law firm Anderson & Krieger. With me is Nina Pickering-Cook, a colleague of mine from the firm, and we are representing this morning the Investigations and Enforcement Bureau.
Is that it? Thank you, Counsel. At the conclusion of my opening comments, this proceeding will commence with a recitation and explanation of the investigative report by the Bureau. We will ask that the Bureau outline the manner in which the investigation was conducted and outline the findings relative to each qualifier. The Bureau's presentation will largely be made by Karen Wells, who is the Director of the Bureau. Director Wells is joined by the consultants who assisted in the conduct of the investigation. We will allow the consultants to offer any clarification or answer any questions during Director Wells' presentation. Any commissioner may ask a question of Director Wells or consultant at any point during or following her presentation. At the conclusion of the Bureau's presentation, the applicant, through its counsel, will be afforded an opportunity to cross-examine Director Wells or consultants relative to any of the information contained in the investigative report or to which they testified. The applicant may reserve its right to cross-examination until the end of their own presentation if they so choose. Next, the applicant will be given an opportunity to present its case. The burden is on the applicant to demonstrate by clear and convincing evidence both its affirmative qualification for licensure and the absence of any disqualification for licensure. To that end, the applicant has already subjected itself to a thorough background investigation, the results of which are set out in our investigative report. Those findings will be considered in determining whether the burden of proof on the applicant has been satisfied. For purposes of this proceeding, however, the applicant may call any witnesses and present any other evidence it desires in an effort to satisfy its burden. The Director of the Commission has directed that at a minimum, Scott Butera, Rodney Butler, Crystal Whipple, and David Nunes be available to present testimony as to the issues set forth in the notice of this hearing that was provided to the applicant. Are those four parties here?
Yes.
I understand that counsel for the applicant had an opportunity to meet with counsel for the Bureau and the Commission to discuss this proceeding. The purpose, in part, was to clarify some of the issues that the applicant should address in its presentation. Those are primarily the issues that are set forth in the written notice of this hearing. Is that correct?
That's correct, Mr. Chairman.
While those areas should be included in the applicant's presentation, it may certainly address any other issues it believes may be relevant to its suitability determination. Similarly, the commissioners may certainly inquire into any issue that is of interest to us. At the conclusion of each witness's testimony, counsel for the Bureau will be provided an opportunity to cross-examination of the witness. Then each commissioner will be afforded an opportunity to ask questions of the witness. Any commissioner may, however, ask any question of any witness at any time during an examination or at the conclusion of the examinations. We will allow very limited redirect and recross of a witness if it is absolutely necessary. Either party may raise objections they desire at any time. However, the basis for all objections must be clearly stated. Finally, at the conclusion of all the evidence, the applicant will be provided an opportunity to make a closing statement summing up why it believes that it is suitable to be issued a gaming license and should be allowed to proceed to the Phase 2 portion of the process. Before we begin, I understand that there are a number of pre-marked exhibits that have been exchanged by parties in advance of this hearing. I'll now ask the Bureau's counsel, Mr. Mackey, to introduce the Bureau's exhibits.
Yes, sir. We have pre-marked 16 exhibits that we are going to introduce on behalf of the Bureau. The first 4 are the notice of the proceeding. Then there's the memorandum regarding the conduct of this adjudicatory process, the cover letter by Director Wells, and the redacted suitability report. We have also pre-marked a number of other exhibits, the sworn testimony of the witnesses that we anticipate the applicant will have testify, as well as some other documents that we may use in connection with the questioning. I have exchanged these documents with Mr. Allen. He has no objection to the introduction of any of them.
Are there any objections to these exhibits being marked and entered into evidence?
No, there's not, Mr. Chairman.
Now, if the applicant has any exhibits which it would like to introduce, I'd ask that they be introduced.
We do not at this time, Mr. Chairman.
Okay. So I assume there are no objections. If either party would like to have any additional documents entered into evidence during the course of the hearing, I'd ask that they be properly introduced and marked by the court reporter. The Commission anticipates that its inquiry at this proceeding will be limited to matters addressed in the investigative report. In the event that a line of questioning conducted by the Commission or Bureau moves into an area that has not been included in the report, but that is included as part of the investigative file and is material to the suitability determination, the applicant may request a recess in the proceeding so as to review the issue. This would be an unlikely happenstance, however, as the Commission anticipates addressing solely issues covered in the investigative report. No final decision will be made at the conclusion of this hearing today. Instead, the matter will be taken under advisement at the conclusion of the proceeding and a written decision ultimately issued. If at any point during the Commission's deliberations it determines that further testimonial or documentary evidence is desirable, it reserves the right to ask the applicant to provide such evidence prior to a suitability decision being made. We will now swear all of the witnesses in. Anyone who will be testifying at this proceeding, please stand and raise your right hand.
Just in case.
Wow.
Just in case.
Do you all solemnly swear that the testimony you will provide before the Commission at this proceeding will be the truth, the whole truth, and nothing but the truth?
I do.
All have answered in the affirmative? Thank you all. Before we begin, does council have any preliminary issues or objections on either side?
None with us,
About
Mr. Chairman.
Ground rules?
Yes, no, sir.
With that, I ask Attorney Mackey to begin the Bureau's presentation.
Okay, and we will begin with a presentation from Director Wells.
Good morning, Mr. Chairman, members of the Commission. As a preliminary matter, I really would like to thank the Massachusetts State Police and the firm of Michael and Carroll, who were instrumental in conducting this investigation, really did an excellent and thorough job. The applicant before you today is Crossroads, Massachusetts, LLC. The proposed site of the Category 1 casino is on 187 acres on the eastern side of I-495 in Milford. As identified in my cover letter and the accompanying suitability report, the glaring issue for the applicant is that they have not secured a 55% equity ownership interest for the proposed project. As such, I cannot even reach the point where the IEB can even make a recommendation to the Commission as suitability because the majority equity ownership hasn't even been identified yet. So as a preliminary matter, that's where we're starting from. I have indicated to the applicant as their burden to demonstrate suitability to the Commission, and it's not possible for me to do that without a complete deal in place. The suitability report does contain information on the applicant as it now stands, and the IEB identified certain issues which the commission should consider at a hearing if it wishes to proceed. The investigation to date reviewed 10 entity qualifiers, including Crossroads, and 12 individual person qualifiers. Crossroads, Massachusetts, LLC is owned 100% by a number of entity qualifiers. Ajax Gaming Ventures, LLC, wholly owned by David Nunes. RMP Massachusetts Gaming, LLC, wholly owned by 2001 A&A Trust, whose managers are Robert and Alan Potamkin. Etkin Massachusetts Gaming, LLC, wholly owned by Five Trees, LLP, the managing member of Etkin Gaming, whose general manager is Bruce Etkin. White River Gaming, LLC, owned by Jeffrey Meiji, Timothy Prizzuti, Timothy Bell, and John Seedham. Crossroads entered into an agreement with Mashantucket Pequot Gaming Enterprise, an unincorporated instrumentality of the federally recognized Mashantucket Pequot Tribal Nation, who does business as and operates the Foxwoods Resort Casino in Connecticut. Upon that agreement, MP Enterprise will provide assistance in finding an investor for the remaining 55% of the equity ownership. However, to date, as I have previously indicated, that never occurred. Once that equity ownership is secured, or according to the agreement would be secured, they will commit a certain amount of money and obtained approximately 10% interest in the gaming licensee. However, given that they have not obtained that 55% interest and that there's 10% through the Foxwoods Group or the MP Enterprise Group, that really lowers the percentage of actual equity that the applicant now possesses at about 35% of what they need for this complete deal. As a result of the partnership between Crossroads and MP Gaming Enterprise, Crossroads formed FCX Massachusetts, LLC, for the sole purpose of pursuing gaming interests in Massachusetts. That entity will now serve as the development arm of Crossroads. Crossroads management structure, they have Scott Butera as the president, Bruce Etkin, the VP of Development and Assistant Secretary, Robert Potamkin, the VP of Strategic Planning. Secretary is Tim Prizzuti, the VP Finance and Treasurer. Functional positions within Crossroads include David Nunes as the Chief Development Officer and Alan Kronberg as the Project Manager. Scott Butera is also the CEO and President of MP Gaming Enterprise and was appointed to serve as President of FCX. Crossroads was founded by David Nunes and William Warner. The contracts for the purchase of the land of the proposed casino site were held by Nunes LLC, Ajax. Once Nunes formed the partnership with Warner, who had just formed Warner Gaming LLC, the land was assigned by Ajax to Crossroads. Warner became less involved in the project and has redeemed all of his remaining interest in the Crossroads application. Needing additional equity finance, Nunes' friend Robert Potamkin agreed to make an investment through his LLC, RMP Massachusetts Gaming LLC. Robert Potamkin told Bruce Etkin about the opportunity, and Etkin also agreed to make an investment in Crossroads through his LLC, Etkin Massachusetts Gaming LLC. Timothy Prizzuti, another friend of Nunes, agreed to become an investor along with 3 others whom Prizzuti was acquainted. White River Gaming LLC was formed by Prizzuti, John Seedham, Timothy Bell, and John Meiji. Mr. Nunes contacted Butera with the opportunity for MP Gaming Enterprise, That formed Foxwoods Mass LLC for the sole purpose of managing the affairs of the proposed casino resort project in Massachusetts. Mr. Butera, Mr. Butler, and Ms. Whipple constitute the board of managers. Upon securing the new equity, which I previously mentioned, according to the paperwork that they filed with the IEB, Foxwoods Mass will have decision-making authority over the day-to-day activities of the Crossroads Casino licensee, along with the other major decisions concerning business and affairs of Crossroads. The licensee to be the decisions are to be vested in the Board of Managers, which I indicated includes Butera, Butter, and Whipple, with at least 1 designee from the original Crossroads investor group, 1 designee from the Foxwoods Massachusetts investor group, and not more than 4 designees from the new equity group, subject to supermajority voting rights to be mutually agreed upon. Foxwoods, Massachusetts will have primary responsibility for designing, developing, constructing, equipping, and furnishing the casino resort project, and be entitled to a development fee equal to a portion of the overall cost of the project. While on paper this exclusive authority rests with Foxwoods Mass LLC, it is certainly a legitimate area of inquiry for the Commission as to whether this wall between the LLC and the tribe is expected to be real when it would effectively occur in practice, particularly in light of the concerns described in the report regarding the criminal issues surrounding Michael Thomas, Stephen Thomas, and Anthony Beltran. That is why the IEB identified those issues for the hearing today and for the applicant to come forward and address. As detailed in the report, the IEB also believes the applicant should address the suitability of Mr. Nunes, given information contained in the report, including the internal conflict within the partnership, his communication with the IEB about the status of the proposed equity partner, and most notably, the assignment and repurchase agreement he entered into with Warner to make it appear that an entity with gaming expertise had a larger percentage of Crossroads when in fact it was a meaningless exercise whereby he was to buy back the interest after filing the application. The IEB also informed the applicant it should come before the Commission and demonstrate at this hearing that it has the business ability to run a successful gaming operation in Massachusetts, given its difficulty in finding additional equity interest and the current debt load and declining revenues of their proposed operator. Details on this issue can be found in the report. Additionally, concerns were recently brought to the Commission's attention regarding the applicant's representations regarding the position of DOT on the highway issues by Representative Dykema. I believe the Commission has received that letter and the applicant has been notified that should respond to that issue to the Commission. Overall, as I've stated in my letter to the Commission, the IEB is really just not in a position to make a recommendation regarding suitability because we don't have a complete picture of what this applicant is going to look like. I'm particularly concerned because there's a majority equity ownership that's missing, and if there is some kind of deal in place, once you get a majority ownership in place, I don't know at this point whether that's going to change the structure of how things work. So I'm particularly concerned about that. And also this wall between the LLC and the tribe. The tribe were not deemed qualifiers because on paper, these people in the LLC would have the exclusive decision-making authority. But I think it's a legitimate area of inquiry for the Commission to ask and the applicant to present evidence to the Commission to satisfy the Commission. That's really going to take place in practice because we could always make a decision to have additional qualifiers. If that's not really what's going to happen, then we would potentially need other people to be qualifiers and check on the suitability of other members, including members of the tribe. So given where we are right now, I've had conversations with the applicant and indicated that this hearing is somewhat unusual in that I can't make a recommendation because we don't even have a complete picture, but it's their burden to come before the Commission and address these issues. And we've had discussions that they need to come before the Commission, address that, indicate what they plan to do if we can even go forward, because I can't tell you what this whole application looks like. So that's really all I have for today.
Okay, what's next? Are there questions back from, do we go then to your response?
I believe so.
Okay.
Thank you, Mr. Chairman, and thank you, Director Wells. First, let me, I know you want to hear from Mr. Butera, and particularly relative to the equity position, and we will get into that. I want to thank you for the opportunity to present here. I want to thank Director Wells, the State Police, and the investigatory team for doing a thorough job and their expertise in this area. I do want to introduce everybody at the table because I don't think we have done that yet. Scott Butera is to my right. He is the president of Crossroads. With him is the chairman of the Mashantucket Pequot Tribal Council, Rodney Butler. The vice chair-elect, Crystal Whipple, is a couple rows behind. To his right is counsel, who you've met, and John Hickey, who was the drafter of most, if not all, of the corporate documents, and David Nunes is at the end. We also have Robert Potamkin, Alan Potamkin, and Bruce Etkin behind me. I also want to note that Town Council Kim Kopp from Chicago, who represented Milford, is a couple rows behind me also. We're pleased to be here today, and while we certainly understand the issue relative to equity, we're pleased with the outline of the report, because we do feel that through this extensive and thorough investigation, there were no real issues that would make any of the people before you here today not be found suitable. So we're pleased that the good character and the honesty, integrity came out in our individuals after this investigation. I do want to be clear before Scott takes over, is that throughout this entire process from January 15th till today, there has never been a time when we haven't been open and honest and kept the commission apprised of every step along the way, including where we were with the equity. We were always very clear about that. We weren't trying to play any games, or we weren't trying to deceive in any way. Even when the issue came up of Mr. Warner leaving, we were clear with the commission at that time, and always Director Wells and I had an open line of communication. Our presentation today is really going to focus on the 5 issues that Director Wells raised, but I do think it's important, since one of the issues of suitability is suitability of the site, and as far as I know, this commission is not aware of what this site looks like and what our proposal is. So with your indulgence, Mr. Chairman, Scott would like to give a quick little overview of what this project's going to look like. And you will hear Mr. Butera get into the explanation of the gaming operation at Foxwoods, the debt restructuring, and the equity piece of it. And with that, I'll turn it over to Scott.
Okay, thank you, Bob. Chairman Crosby, members of the commission, Director Wells, on behalf of Foxwoods and Crossroads Partnership, I would like to echo what Bob says. We are very thankful to be before you today. And I would also like to say we're very appreciative of the efforts of the commission and its advisors throughout this process. We've found it to be very fair and balanced and informative. And having been in the gaming business for most of my career, I will say it's been one that's been done very well. So congratulations to you and your team. As Mr. Allen said, I do want to talk a little bit about the suitability of the site and why we feel it's such a compelling opportunity for Massachusetts. And since getting to know Milford from the beginning of the year, what we found is Milford is a very...
Excuse me, Mr. Butera.
Yes.
Is it possible to get the screen on the feed, on the web feed? Can't do that? Okay.
Okay. As I was saying, having spent the better part of this year in Milford, Massachusetts, what I'll say is it's a very robust and proud community. It has very strong leadership, and it has citizens that have a great sense of social responsibility and history. And what we really wanted to do is come up with something that best represents how that community feels. Like with any real estate project, location is always critical. And we feel that we have an outstanding location for Massachusetts in terms of being able to capture revenue, not only from the Boston area, but really throughout New England. And, you know, as an operator only 140 some odd miles away, we feel that, I'm sorry, within 50 miles, we feel that we know this market extremely well. And in fact, many of our customers already reside in this area. So we think the location is outstanding. In addition to having an outstanding location, we think we have an outstanding site. And by site, I mean topography of the land. As Director Wells says, we have 187 acres, most of which will not be used, which will allow us to create a lot of outdoor natural areas and have a project that we think will be very green. As you can also see, we're very proximate to 495. And in fact, we believe that over 95% of traffic that will come to the facility will come from 495 and will not invade local streets. And the site right now is currently undeveloped, so that we think that we can get in there and work on this project in a way that will be as non-invasive as possible for a project of its scale. So, you know, we think that the actual site itself, the community, and the topography provide a great starting point for an outstanding development. As I mentioned, you know, the site is right off of 495. It's only 10 highway miles from the Mass Pike and only 20 miles from I-95. So again, we think we'll have great access throughout the New England community. In addition, because we are so close, we'll be able to offer a connector road that will come right from 495 through Route 16 to our project and provide direct and simple access to the facility. And I can tell you, having operated, as I said, in the gaming business most of my career, convenience is usually the #1 factor in determining a person's decision to come to a facility. So we think this facility will be very convenient, even for those in the city of Boston, where they can easily get on the highway and come in and out without having to deal with a lot of traffic or other things that could be preventative. So we're really excited about our site and its access. In terms of providing, a great setting for a casino, one of the other things I'd like to say is we also think that because we're in the suburbs, and in Foxwoods we're used to operating in the suburbs and being a drive-to destination for major metropolitan areas, we think that we can be a great complement to those businesses in Boston as opposed to something that competes with them, which also we think is important. And what we wanted to do in talking about like the history of Milford and Massachusetts and New England was come up with something that was a New England style, almost grand resort. I can tell you that most gaming jurisdictions are different in terms of customer base and customers' desires and wants. If you talk to any slot manufacturer, they'll tell you that a slot product that works in one market isn't, guaranteed to work in another, just because people have different tastes. So what we did is we wanted to come up with, given that gaming is new to Massachusetts, we wanted to come up with something that, yes, incorporated gaming, but also incorporated many other recreational and entertainment elements that people from the New England area that didn't particularly want a game could still come and enjoy. So we think that we've been able to create that. In terms of the location, once more, we think it has, again, the highest potential revenues, because of its proximity, and because of, we think Foxwoods' unique ability to operate a facility in this location. As I mentioned, Foxwoods has a active customer base of over 1 million active members, 300 million total members. Almost 40% of our active members come from folks that are proximate to where this facility would be located. So we think that we have an ability to service an existing customer base that we know quite well. We've been operating at Foxwoods for over 20 years. We have great history with a lot of these folks, and being able to offer them a product that's closer to home, we think is, again, extremely compelling. So in terms of, just back to the New England Resort, what we've done is we've created to do something that we think best represents that New England Resort feel. We actually created a team that was basically entirely based in the New England, or if not Boston area. Our architect is CBT, which is located in Boston. Tetra Tech is our chief engineer. And most of the people that have been involved in the project know, like, and have lived for a great portion of their life in this area, and we're able to apply that expertise in helping to come up with this vision. In terms of what we're going to do for Milford, one of the things is we're going to invest over $100 million in new highway infrastructure and improvements to transportation amenities. This will all be, self-financed. We're not asking for any grants or concessions for that. So we intend to actually widen 495 and create new lanes. We're going to create a connector road. And as I said, I think that more than 95% of the traffic to this resort will come from that thoroughfare. We will also spend money to improve certain intersections throughout Milford and the surrounding communities, so that anything that could be impacted by our facility from a traffic standpoint will be dealt with on our behalf. And obviously, our team has had meetings with various federal, state, and local officials, including Massachusetts DOT and the surrounding communities, to work on this project. One of the things and these are just, some more projects, one of the things I want to talk about in coming up with the vision of this project is if you look at this facility, I use the phrase that I don't think there's anything in the world that calls itself a casino that looks like this. I mean, to me, this is a project that could be a campus at one of the colleges here, or certainly a resort in this area. And we went to great lengths to study the history of architecture in New England, everything from the actual design of the buildings to the materials that will be used therein. And we think we've come up with something that is a very modernistic approach to the great history of this area. In terms of one of the things I'd like to touch on is sustainability. We feel very strongly that the resort needs to be sustainable and as green as possible. On the 187 acres that we're developing on, which you can see in the upper left-hand side, we're actually only going to use 15% of that land for our development. The remaining portion we will develop, but develop as green space. So we envision a lot of outdoor recreational facilities, town greens, places where people can meet, hopefully do nature walks. There's a very good bike trail there that we're going to work on developing. So we think that it's going to be an attraction not only for people who enjoy what I'll call indoor entertainment, but also outdoor entertainment. And beyond that, we're also going to be working to make the building itself sustainable in terms of renewable energy and green roofs and things of that nature. So we're going to invest a lot of capital in the project toward that end. And the whole idea is that this is something that's meant to be elegant, not opulent. And I've been in many other gaming jurisdictions. I've worked for a long time in Atlantic City and in Las Vegas, and they're just different. The markets are different. I'm from the Boston area. I lived most of my life in New England, and I know when I moved my wife and 3 kids to Las Vegas in 2005 because I was CEO of Tropicana at the time, it was quite a shock to their system. So I think when we do this, we're going to do it in a way that this community will appreciate and feel very proud of. In terms of the actual facility, we'll have the largest gaming floor, I believe, of any of the applicants, with over 200,000 square feet and 6,700 positions. We'll also have a very nice 500 room hotel. That'll be of the same quality that one might see if they were to come to Foxwoods. I think Foxwoods has probably some of the nicest hotel product of any gaming resort. We intend to have fun and also elegant restaurants and clubs, obviously bars and lounges. And in addition to that, we're going to have a strong retail product. We're going to have entertainment, which will take place in our banquet and meeting space. And we're going to have structured parking, and again, toward the idea of being green. Obviously, we have a lot of land, and we could have gone with surface parking because of that. And in many regards, customers prefer surface parking. But obviously, we thought the more responsible approach was to have structured parking. And in fact, if you can see the sort of gray area of the building, that's the actual parking facility. And we talk about convenience. One can actually get from 495 into that parking structure and onto our gaming floor within 5 minutes, which is just about as convenient as it gets. So again, because of the site and because there's raw land there, it offers us a great opportunity to do something that is very compelling from that standpoint. We've undergone, and this gets into Director Wells's comments about our equity raise. We've undergone as comprehensive a process as one could go through with the town of Milford, and I really commend the town and its advisors for identifying what the critical issues would be for a town. What we've always told them is, ironically, what their main issues are also the main issues for a casino operator. Things like traffic and access to energy and having access to water and all those kind of things. Obviously, if you don't have any of that, you can't run a great facility. A facility needs to always be clean, safe, fun, lit up, and you know, I think that fortunately for both of us, we were all focused on the same things. But we did go through a very, very long and comprehensive process. Not only did we have to hire a full team to produce the materials that we've produced, but the town itself hired their version of a full team, and we were able to compare notes with them and work through a process. And we went through things like real estate values, impact on schools, obviously traffic, water, sewage, wetlands, the power grid, you know, again, everything that they would be concerned with. And in negotiating our community host agreement, that was the result of that very, very comprehensive and informative process. I think we had 7 meetings with the selectmen. We had many town hall meetings where every citizen was invited to and allowed to ask questions. You know, these were meetings that would go late into the night. But one of the great results of all that is I think that we have a project, and as an applicant, I think we have a project that has great visibility. And by great visibility, what I mean is what you see is what I believe you will get, because we're not just doing this based on schematic designs or conjecture. This is the result of many, many hours of hard work, many meetings, and I think the result is something that we all feel very comfortable can be achieved along the lines of what we're presenting. In terms of what the impact will be to Milford, it is significant for that town. Obviously, we're going to be investing over $1 billion in the project itself. We'll create over 3,000 construction jobs and 3,500 permanent jobs. I always like to mention when we talk about jobs with any casino, the diversity of jobs within a casino. You know, so there are so many different types of businesses, as I mentioned, within a casino facility. I know at Foxwoods we have over 150 different types of job descriptions. So you could be a gaming professional, a food and beverage professional, a financier, you know, or somebody who works in banquets, or you know, that type of thing. Just you know, construction people, you name it. So there are a lot of jobs. They're all fairly well-paying jobs, and they all come with good benefit packages. It seems like I can't turn on the news today without hearing about health care, and we're probably the leader in providing health care to all of our employees at Foxwoods, and would bring that same approach to Milford. In terms of direct economic benefits to Milford, we will be providing them with over $30 million in upfront payments and over $30 million in annual payments. And those will go to things like real estate taxes, fire and police, utility and infrastructure. There'll be a residence impact fund for those who feel their property values were impacted. We'll also be providing money for school aid and development grants. So obviously, if you add all of this up, it comes to over $1,000 per citizen, which is well ahead of any other community on a per citizen standpoint. And then here are just some more renderings of the site where you can see how the parking garage actually circumnavigates the facility itself and provides great access. So in terms of, you know, what's next for us, obviously we're working really hard on our Phase 2 application. We're really excited about that. We have a complete team working around the clock on that. We do have a referendum in Milford on November 19th, and we're working hard to get a successful vote there. We will also need a zoning change, so the town council will have to vote on that shortly after our referendum. And if all goes well, we believe that we could open this facility sometime in the fall of 2017. So that concludes my remarks on the actual site. I'd like to spend some time talking a little bit about Foxwoods and its how we got involved and the benefits of our recent financial restructuring. Foxwoods, I came to Foxwoods 3 years ago. Foxwoods, as I said, has operated in the state of Connecticut successfully for over 20 years. During 2006 and 2007, when the economy started to turn, not unlike many other operators, Foxwoods was in the process of expanding and opened a large facility in 2008. And unfortunately, that's right in the heart of the economic crisis. Revenues were going down, jobs were being lost. And unfortunately, because of the debt burden that was put on the casino resort at that time and what was happening in the economy, they ran into a little bit of financial difficulty. So I was brought in to restructure the enterprise's finances and restructure its operations. Having done this restructuring practice for a lot of my career, I will tell you that this is by far the most successful outcome I've ever been involved in. We had, when I joined Foxwoods, we had approximately $2.2 billion of debt. In order to do the type of restructuring that we needed to do, where we reduced our indebtedness, extended our maturities, and lowered our interest rates, you have two choices. You either get consent of 100% of your holders, and just, to give you some numbers, we had over 6 tranches of debt, 160 some odd institutions. Doesn't sound like quite an achievable thing. Or you can file, for bankruptcy and have a court, impose that. We, after much deliberation, decided that we would actually attempt to get a consensual deal done. We spent over 2.5 years working on it, and I can proudly say that we, on July 1, concluded a consensual deal where all but $300,000 of the $2.2 billion signed up for our deal, which is astounding. And that $300,000, by the way, has a trust set aside to pay that money off. We just couldn't find the people that held that. But virtually every holder of our securities was involved in the negotiations and successful conclusion of this restructuring, which to me means it was something that obviously they felt very good about. But one of the great benefits of that restructuring is it put the tribe in very strong financial condition. We reduced our indebtedness by over $550 million. We extended the maturities on our debt significantly. Our most junior debt doesn't, our first tranche of our junior debt doesn't come due until 2026. All of our debt is at interest rates, single-digit interest rates, and we have substantial coverage in terms of our EBITDA to fixed income payments, which would be our principal and interest payments. As Director Wells says, we have experienced declining revenues. That's been the result of a couple of things, obviously economic conditions, but more importantly, new competition. So, in my experience in real estate, one of the benefits of a down market is supply also goes down. So when you emerge stronger. But unusual times created the need for gaming revenues in certain states. So we had the weird situation where revenues were declining and supply was going up, which kind of defies logic, but that's what was happening. So we had to deal with all that. So, whereas Connecticut was a $2.2 billion gaming market and there was no Pennsylvania and there was, no New York City, now Pennsylvania is over a $2 billion market, New York City soon to be a $2 billion market, and all of those have customer bases which we compete with. So, basically if somebody opens up a Walmart right next to your Lowe's, you'll probably experience some declining revenues. That doesn't mean you can't have a great business. That just means you have to change your business profile. When I first started covering gaming many years ago, gaming revenues in Las Vegas represented about 75% of revenues. Now they represent 40% because they went through a similar thing where there was no California, and then all of a sudden California had casinos everywhere. So what Vegas did is it transformed itself and created other sources of revenues, restaurants, nightclubs, entertainment facilities. We're in the process of doing the same thing at Foxwoods. And in fact, even though our revenues have been declining, our cash flow and our bottom line has been improving steadily since I've been involved with the company. And we expect that to continue. And that's been the result of operating a lot more efficiently, getting out of unprofitable business lines and supplementing some lost gaming revenues with other gaming revenues like hotel revenues, convention revenues, banquet revenues, things like that. If you were to come to Foxwoods now, you'd see an incredibly robust environment. There's quite a bit of redevelopment that's going on. One of the great benefits of our restructuring is it provided a fair amount of cash for us to invest in projects, not only at Foxwoods, but obviously in other jurisdictions like Massachusetts. So right now, we're renovating rooms, we're renovating retail stores, restaurants. We just broke ground on a 300,000 square foot outlet center mall, high-end outlet center mall, which we're developing with Tanger Outlet Centers. So quite a bit of money is being spent at our facility at home, not only on the physical plant, but also on our marketing programs and training our professionals. And we also have a fair amount of money to diversify, because one of the things restructuring taught us is, diversity is good, and, having, being in multiple jurisdictions is obviously better for your business. So I think to address the financial situation at Foxwoods, I think, we've done a great job. I do pay a lot of credit to the tribe and Mr. Butler and the Tribal Council, because they, I think, did what was right. They obviously reduced, a lot of the money that was going from the enterprise to the tribe. I think we probably, right now, we're just paying the tribe for essential government services. It's probably 30% of what the enterprise used to pay the tribe. So everybody did what it took to make sure that the enterprise would be in good financial condition and was something that would be sustainable for many years to come. All of our restructuring plans were done with the notion that there would be gaming in Massachusetts, and worst case scenario, we wouldn't be a participant in that. So, whether or not we're successful here will not have great impact on the Foxwoods Resort. So we feel very good about where we are from a financial standpoint. In terms of the equity raise and why we are still working on that, obviously, as you can see from the process, there was a lot to do. We at Foxwoods got involved really in February and the beginning of the year, but in earnest, once we knew our restructuring was going to be complete, because obviously we needed to be able to complete that in order to make this investment. I'd say that we probably started out in the eyes of the investment world as a bit of an underdog. We really hadn't had any plans at the time, so we had to develop our plans. We had to work with the town. Investors wanted to see that we had an agreement with Milford. Obviously, that took a lot of time to get to that agreement because of the process I described. But I will say that since all of that has been done, we've been actively involved in negotiations. We have two, very, very strong offers or opportunities to fill that gap, which we're in the short strokes of negotiating right now. And, I'm confident that we will, in short order, have that done. But really, the reason we're not here now with that having been completed is just a result of what the process has been and kind of the natural order of how these things come together. And
Excuse me, when did you finish your restructuring?
July 1.
Of this year?
Yes, that's correct. So, and I will say that most recently, I would say that people view us as a much stronger candidate and one that has a great chance of securing this license. So with that, hopefully I wasn't too verbose. I'll conclude my remarks and ask if there are any questions.
Councilor, Commissioners? Starters?
Begin.
Go ahead.
Good morning, Mr. Butera.
Good morning.
Let me just begin where you left off with the equity investor. And I understand that there may be confidentiality concerns about identifying who in specific terms, but to the extent that you can you describe more fully the entities you're talking to, the terms that you're discussing, and specifically when you anticipate coming to closure on this? Sure,
I will. And we are under confidentiality, and obviously when you're in the process of negotiations, confidentiality is important, to the success of those negotiations. We have two offers that, I think one of which we will select. They're a little bit different in structure. One is with a, what would be considered a private equity fund that it has been involved in gaming, has been licensed in other jurisdictions, whereas they would provide approximately $350 million of equity for the project. They would obviously share in any future distributions with the Crossroads partners, and they would obviously be involved in the governance of Crossroads and the development of the project. That would be for the equity portion. I can say that on the fixed income portion or leverage portion of our deal, we have been working from the beginning of this project with Deutsche Bank, which is one of the leading financiers and advisors to the gaming community. They will be providing a senior note that will finance a majority of the project, and they will be providing a highly confident letter for that note. That, I think that portion is secure. It's really the equity portion. So the first would be, just basically what I'll call a straight up, equity funding. And there would be an arrangement where Foxwoods would get a development fee, a management fee, and a licensing fee for our use of our database and our brand. And then there would be, like I say, a split of any future distributions. The second entity...
Let me just stop you there for a second, because I want to... with respect to this first option that you identified, would the current management operating structure that were outlined in the course of the suitability investigation, would that remain in place, or would you anticipate this new investor, given their stake, would make some significant changes there?
No, I think it would stay in place. I think, obviously they would be, very involved in the governance. So they would, obviously, if there was a board, they would be on the board. They might have a majority of that board. But the actual structure is one that's contemplated under the deal that we're talking to them about. So they would basically join as a new partner.
Okay. So I guess just to put a finer point out of the entity that's, I think it's, the formal name is Foxwoods Massachusetts LLC, would remain in place even under this first option that you're considering.
Correct, right. Yep. And then under the second option, it would be with a publicly traded company, so confidentiality is a little bit important. And what they would do is they would actually provide funding. They would provide funding for the real estate portion of our development. So anything that would be considered a real asset, which would be the building, the infrastructure, obviously not the license or things like furniture, fixture, equipment, stuff like that. But the actual building, they would provide what I'll call sale-leaseback financing. We would basically sell them all of the real estate and we'd lease it back for a rental payment. And then for the remaining fund, that would cover the real estate portion. Then for the non-real estate portion, they would be providing us a 7-year funding for that piece. So a little bit different structure where it'd be bifurcated into, a loan and a sale of real estate as opposed to an equity and debt structure, but it would basically cover the same total amount. And the
total amount being the $350 million.
Well, being the $1 billion or
So that would
whatever it takes to build the
Deutsche
facility.
Bank would not be involved in that deal.
In that deal, it's unclear that Deutsche Bank would be involved as an advisor, but not a lender. So we wouldn't need a loan because essentially we'd be selling our real estate. So the biggest portion will either come in the form, the majority of the financing will either come in the form of a loan from Deutsche Bank supplemented with an equity investment, or a sale of our real estate supplemented with a loans, mezzanine type loan / equity investment from that entity.
Okay. And then same question with respect to
And under both circumstances, I just want to clarify, Foxwoods would be the manager. So we would be involved, we would be the ones controlling the development of the resort and the day-to-day operations of that resort.
Okay. According to the same structure that's been outlined previously, the Foxwood Massachusetts LLC entity in the sort of direct control relationship of the facility here in Massachusetts.
That's correct.
Okay. All right. I wanted to ask you a few questions regarding the issue that Director Wells raised in her remarks regarding this, in effect, wall that has been set up in the operating agreement between the Foxwood Massachusetts LLC.
Right.
And then MPGE, it's referred to in the documents, I guess the enterprise, is
Right.
that how you would refer to it?
Yeah.
Okay.
I'll address that, and we also have Jackson King here, who's counselor for the tribe, that can also address that. This is a structure that's actually been used quite a bit in the gaming environment. I think it might have started with an entity called Colony Capital, where the Colony was one of the first private equity funds to invest in gaming. And in order to not have all of their limited partners have to get licensed, they set up a structure where you had a control entity. So really, we just mirrored, what I'll call the Colony Capital structure, and it truly is an independent governing authority. So all of the Foxwoods, Massachusetts decisions are done with Rodney Butler, who is the chairman of the Tribal Council, and Councilor Crystal Whipple, who's here today, and then myself as a third. And none of those decisions are conferred to with either the remaining council or the tribal members.
Okay. I just want to back up and sort of track the development of this structure over time. And it's reflected in the documents that we've offered up to the commission, and I don't necessarily burden the commission with review of each of these documents, but as I understand it, back in March of 2013, February and March of 2013, there was a different structure envisioned at that point. Wouldn't that be fair to say?
With regard to the tribal
With regard
enterprise?
to the relationship between the enterprise and Foxwood, Massachusetts.
I don't believe so. I don't believe so.
Okay. Well, why don't we take a look then? Do you
Sure.
have, Mr. Allen, the exhibits that we offered? Exhibit number 9. Is that a document that you recognize?
Yeah.
I think it may be best for Mr. King to look at this.
Okay, that's fair enough. Let me just represent for the record that it's a resolution passed by the Tribal Council, and it authorizes a binding letter of intent with Crossroads. And the top of page 2, if I could just ask you, Mr. Butera, to turn to the second page of the document. Or if Mr. King is the more appropriate person
Yeah.
to direct these to. Okay.
Yeah, I'm probably more familiar with it.
Okay. That's fair. I have no concern about Mr. King answering directly. The top of the second page, Mr. King, the whereas clause, it says, MPGE, the enterprise, desires to enter into a binding letter of intent with Crossroads, which is attached as Exhibit B. Do you see that?
Yes.
Okay. And then at the very bottom of the page, it says, MPGE, again, the enterprise, will have primary responsibility for managing the project, and in return, MPGE will receive a management fee equal to 1% of gross revenues. Do you see that? Okay. So it looks that, at least at this point in time, and this was signed in March 2013, the resolution was passed in March 2013, that MPGE, the tribal enterprise, would have direct control over this project.
Well, that is the gaming enterprise
Yeah.
that Mr. Butera is the CEO of. That's right. There was no third entity formed at that
At that
point.
time.
But let me clarify. So MPGE, which I, am the president and CEO, we report to the tribal council.
Understood.
Yeah.
In effect, I guess just, the way I think of it is MPGE is the operational unit for the gaming enterprise, but the tribal council effectively sits as the board of MPGE, the board of directors.
Essentially, that's correct.
Okay. And then you're the CEO of that enterprise.
Correct.
Okay. And so initially, in March of 2013, the structure was direct control by the tribe over MPGE, which would manage this facility. Is that fair to say?
Yeah, I would say.
Mayor, Mr. King, or?
Yeah, well, I would say that, yes, I would say that that was fair at that time, but, we hadn't contemplated, setting up this structure. so-
Understood, and I know that
Right.
it changed at a point in time,
Right.
but I want to ask about the reasons for the change in
Okay.
just a minute. Bottom of page 4, it just outlines a little bit more how the tribal council, how the tribe will control the entity. The bottom of page 4, it just says, be it further resolved the tribal council hereby appoints the following tribal council members to the committee that shall have decision-making authority for purposes of MPGE's involvement in the project. And then it identifies Mr. Butler and then 2 other individuals as the individuals on the tribal committee, correct?
Correct.
Okay, so just so we're all clear, in March of 2013, the structure was the tribal council with a subcommittee or committee of the tribal council, which would effectively act as the board for MPGE's enterprise here in Massachusetts, correct?
I think that's correct as of that date, yes.
Okay.
But I'm not sure it would be a subcommittee, Jackson. I think it was a separate committee, wouldn't it?
It was a separate
Yep.
committee.
It was a separate committee of the
Yeah.
board. I'm sorry, of the tribal council.
Okay. Yeah.
It was a committee of 3. Yeah.
All right, but then it would be fair to say, well, let me have you look at exhibit number 10, Bureau Exhibit number 10, which was a subsequent resolution of the tribal council authorized on June 24th, 2013.
Or is it June 19th? It doesn't matter, but
The signatures on it are June 24th.
yeah, the
present
resolution
purposes,
was passed on the 19th.
okay, on the 19th.
Yes.
And this reflects a significantly different structure for the control of the Massachusetts facility. Wouldn't that be fair to say?
Yes.
Okay. And just to draw your attention to the top of page 2, the structure envisioned here, Mr. King, is that there is a designated board of managers of the limited liability company, and we referred to that as Foxwood, Massachusetts Limited Liability Company.
Yes.
Which is empowered to act entirely independent of the Mashantucket Pequot Tribe and the Mashantucket Pequot Tribal Council. Did I read that correctly?
That's correct.
Okay. And then on the next page, there are 2 further resolutions. The 6th and 7th, be it further resolves. There's one that reads, be it further resolved, the tribal council approves of a structure whereby the 3 managers, and those are the 3 managers of the Massachusetts LLC, correct?
Yes.
Shall have irrevocable authority to take any and all action that may be necessary to manage the LCC in connection with the potential Massachusetts facility.
That's correct.
Okay. And then the second resolved clause after that is that neither the Mashantucket Pequot Tribal Council nor any member thereof, other than the designated managers, shall in any manner participate in the management or operations of the limited liability company. Did I read that correctly?
Yes.
Okay. So something obviously significant changed between March 19th and June 19th, I guess it was. It went from a situation where the tribal council had a direct control relationship to a scenario where the Massachusetts LLC had sole, exclusive, and irrevocable authority without a relationship to the tribe to run the facility. So can you
That's correct.
explain that? So why did that happen?
Well, because it was recognized that it was a better business structure to have the Massachusetts operation being entirely independent of the tribal council. And the earlier resolution, we felt, did not create as much independence as was created in the second one. We wanted to make it very clear, and we were in contact with the Gaming Commission representatives. We wanted to make it absolutely clear that the 3 managers had the sole and exclusive authority to manage and operate the Massachusetts operation. Exactly what it says.
Okay, and the 3 managers you're referring to are Mr. Butera.
Yes.
And Chairman Butler and Ms. Whipple.
That's correct.
Okay. Now, did it,
One other thing I'd like to just mention, just thinking about the entity itself, Foxwoods, Massachusetts, will be, Foxwoods itself will be a minority owner and manager, as opposed to Foxwoods in Connecticut, which we own 100% of. So that's also gives some credence to why that structure would exist.
Mr. King, you mentioned that you'd had some conversations with the team here at the commission on this issue. In fact, one of the reasons why the structure was set up was because it would not necessitate the qualification of the entire tribal council, correct?
I think that was a factor, yes.
Okay. And in fact, at this particular point in time, when this was set up, Stephen Thomas, a member of the tribal council, had been indicted on a federal felony theft charge, correct?
Correct.
And he was still on the tribal council at that point.
Correct.
And in fact, he was the treasurer of the tribal council at that point.
That's correct.
Let me draw your attention just very quickly to exhibit number 11, which I'll represent is in fact the operating agreement with Foxwood, Massachusetts LLC, authorized by the resolution that we've been looking at. I'm happy to have either Mr. Butera or Mr. King answer. Do you see that document?
Yes.
Okay. And it's, just note for the record, on page 19, Mr. Butera, that's your signature on the document, correct?
Yes, that's my signature.
Okay. Just want to reference a couple of provisions of the document. Section 5.1A, it's on page 2. Do you see that?
Yes.
Okay. And just the very beginning of that section says, except as provided in this operating agreement, the Board of Managers, and again, that's Mr. Butera, Chairman Butler, Ms. Whipple, is charged with the responsibility invested with the exclusive authority to manage the company's business and affairs. Did I read that correctly?
I believe so.
Okay.
The
And
company,
then-
excuse me, to manage the company's business, which company is that referring to?
The Massachusetts
To the LLC.
LLC's
To the
affairs.
LLC.
Right. And then section B, 5.1B, it says, in furtherance of their authority as provided in this operating agreement, the Board of Managers is irrevocably authorized and empowered to perform any and all acts necessary to carry out its function. Did I read that correctly?
Yes.
Okay. And then the next section, 5.2, which is just below that, the last sentence of that paragraph says, in the event any member, and that's the 3 members that we've identified, correct?
That's correct.
And in the event any member resigns or is unable to continue in office, the remaining members shall choose a successor.
That's correct.
So it's envisioned that the enterprise, MPGE, nor the tribal council will have any role even in selecting the board of members of the management board of the Foxwood, Massachusetts LLC.
That's correct.
Okay. And this operating document is still the document that's in force today, correct? It hasn't been superseded.
I don't think it's been changed.
Okay. It still does reflect the operating model and the relationship between the enterprise and Foxwood, Massachusetts LLC.
To my knowledge, it does, yes.
Okay. So, in connection with this model, there is some anticipation here that a management fee would be earned by the enterprise, for example. That's one of the things that it's going to do that's going to generate revenue, correct?
Correct.
Okay. How much is that management fee? Is it a percentage of revenues?
Yes, it's a percent. There's a 1% of revenue management fee, and then there's an incentive management fee based on profitability.
And based on, have you done projections about, order of magnitude of what that would be on an annual basis?
Yes, we have.
Okay, what will that be?
It will be approximately $15 million.
$15 million.
Yeah,
on
and
an annual
we
basis.
also earn a branding fee of 0.25% of revenues.
All right. But who is it who will actually be earning that fee?
The enterprise. The enterprise. Foxwoods Casino Resort.
But it's fairly apparent in the document, though, that the enterprise will have no management role here. The only management role is a role that's being played by the board of managers.
The enterprise will have an operating role, and so not a day-to-day operating role. So in terms of who's controlling, running providing oversight for running the facility, running the restaurants, running the gaming facilities, training the employees, all those kinds of things will be provided for by the enterprise, and the enterprise will earn a fee for providing those services. In terms of any, governance decisions, they'll be made by the committee.
So it's not really the case here that there is this sole, exclusive, irrevocable authority to manage the property vested in the Massachusetts LLC. The enterprise will continue to have an ongoing operational role.
I think by we'll have to, talk about what we mean by management. So the committee, will decide, what services the enterprise will or won't provide. It'll provide that, kind of what I'll call as governance. And then what the, basically the enterprise will be a foot soldier. It'll go in there and do the tasks that the committee, deems that it should be doing.
So again, is the board of directors model apt effectively? So does the three-member committee effectively act as a board of directors over the
Yes.
the enterprise which is managing the LLC?
That's correct. That board acts as that three-member committee acts as the board for our activities with relationships to Foxwoods, Massachusetts. The entire tribal council acts as the board with relationships to Foxwoods, Connecticut.
Excuse me, can I just, maybe if you're going here, stop me, but at the moment, Foxwoods, Massachusetts is the existing investors. Foxwoods, Massachusetts will be modified to the tune of 55% equity investor, one structure or another. How does the committee relate to the new equity structure and the new management situation within Foxwoods LLC?
Well, the committee is not the governance committee for Crossroads or what we're calling that Foxwoods, Massachusetts body. The committee only relates to Foxwoods' involvement in that partnership. So you'll have the partnership, you'll have a governance board for all of Foxwoods, Massachusetts, which we now call Crossroads, and then our Foxwoods is a partner in that. So that three-person committee will govern how our piece of that partnership behaves. And then it'll be a member alongside other members, of that, which would include this new equity partner.
So if Crossroads is Foxwoods LLC, if Crossroads, it will have some kind of a governing body.
Correct.
I guess, some kind of a board.
Right.
And the committee will appoint its representatives on that body and exercise its share of whatever the vote ratios are within the decision-making. Is that right?
Yeah, essentially.
Yeah, essentially that's right. I mean, again, we're primarily the manager. Foxwoods is primarily the manager, so I would say that committee is really governing, the operational, our role with regard to the operational management, and then that a member of that committee may or may not be part of the ultimate Crossroads board, but it could be.
Right.
Mr. Hickey drafted the corporate document, so John, if you want to clarify any issue that was brought up, it might be helpful for the commission.
Butera.
Excuse me,
Oh,
I
I'm
think
sorry.
Mr. Hickey, were you going to say something, Mr. Hickey?
Well, I think in terms of clarification, every operational entity, and in this case, we're talking about Crossroads, Massachusetts, it's going to have its own governing board. That governing board is not going to be controlled by Foxwoods, either the sub-Foxwoods committee that's part of our membership or by the tribal council. In reality, Foxwoods is not going to have a controlling equity interest in the deal, but it will be a manager. So what you have to understand is that there are various levels of governing bodies. And we will have a separate governing board for Crossroads, Massachusetts, which operates the casino. And the members that own interest in there, including Foxwoods, will have a right to appoint a person to sit on that board. But it'll be that board that makes the decisions for Crossroads, not the Foxwoods
Right.
board and not the Foxwoods Tribal Council.
Okay. Okay.
Mr. Butera, if I could ask you to turn to Bureau Exhibit 8, which is, I believe it's 8. Yes, Exhibit 8, which is a copy of the sworn testimony that you gave to Gaming Commission representatives back on August 7th.
Okay.
Are you there?
Yes.
And if you could turn first to page 92, I just want to ask you some questions about some of the remarks you made about the structure that we've been talking about.
Okay.
Okay. You're asked, and this is beginning at the top of page 92 by Ms. Sacco, and for the record, you think that the management contract will be with the enterprise, or will the management contract be with the Foxwood, Massachusetts LLC, which has the 9.9% interest? And then you go on to say, your answer is, however it's structured, the management contract will be owned and controlled by the enterprise. Could there be an intermediary? I don't know. But ultimately, the creditors, and I take it that's the creditors associated with the restructuring
Correct.
that you described earlier.
That's correct.
The creditors, all of that money will go to the enterprise. Anything earned will go to the enterprise, and any resources provided will be provided by the enterprise. And then Ms. Sacco asks, okay, I'm just asking because that could result in additional qualifiers. And your response was, yes, I understand, but that's a very ironclad clause in our restructuring documents. Anything within 150 miles is basically the enterprises. So, first of all, could you explain what you mean there by anything
Sure.
within 150 miles belongs to the enterprise?
Sure. Under the conditions of our restructuring documents, any gaming facility that Foxwoods would be involved in, any monies earned from any gaming activities within 150 miles of Foxwoods in Connecticut would go to the enterprise and to the benefit of our creditors first.
Okay.
So if Foxwoods, if the personnel or employees of Foxwoods are involved in activities within 150 miles, like I said, any money earned would go to the benefit of those creditors.
Okay, and that would certainly include your proposed casino here.
Correct.
Milford. Okay. Then, just a little bit further on, actually the next question, Ms. Sacco asks you, I guess the concern is also because at this point, to the extent that there's, and again, this gets into licensing, but to the extent there's a management contract with the enterprise currently, and the enterprise is governed by the tribal council, which is, for all intents and purposes, the board, and you respond right, then she says then all the tribal members would then have to become qualifiers. And your response is, no, I understand, no, this is controlled by the enterprise. And I'm just wondering, can you explain what you mean by that response, this is controlled by the enterprise? Again, given the corporate structure you've got set up, which has this wall between it and the enterprise in Connecticut.
Yeah, I'm not exactly sure what this is controlled by the enterprise was meant to respond to. But with regard to, what we were getting at, let me just take this quick second. I mean, I don't really understand. I don't really recall what this is. What that response was meant to be. Other than what I'm saying here is that currently if there's a management contract at that time, the management team reported to the tribal council, at Foxwoods.
The management team at Foxwoods, Massachusetts.
Foxwoods, Connecticut reports to the tribal council. Okay. There's no current operational activity at Foxwoods, Massachusetts, at the moment. So.
Okay. Let me try one other. Turn back to page 69 for a minute, just a little bit earlier in your sworn interview.
I'm sorry, page 69?
Page 69. Down to line 20 there, again, questions from Ms. Sacco related to this management structure issue. Line 20, page 69, line 20?
Yes, I'm there.
Okay. The question is from Ms. Sacco, I don't know if you've got this far, but has been decided on how this management structure will be. For instance, will there be certain executives at the enterprise level now that will provide the management oversight for the property level? And you respond correct. Do you see that?
Yes.
Okay. And then you go on to say, I would say the property will have a full management team headed by the president or general manager. So those are people on the ground, Mr. Butera, in Connecticut.
Right, correct.
Whatever you want to call them. And it would have its own executive committee. So it would have a senior marketing official, it would have a senior finance official, it would have a senior human resource official, a senior information technology official, and all the things that you would find in a property of that size. And then that group of individuals would be overseen by the executive committee of Foxwoods, of which I'm the CEO. Did I read that last part correctly?
Yes, you did.
Okay. So who is the Foxwoods executive committee?
Foxwoods executive committee would be myself and 7 of my colleagues.
Okay.
That have similar titles to this.
Okay, based down in Connecticut.
Right. So the way we envision it is Foxwoods, Massachusetts would have its own employees, its own staff, its own senior management team, and then that management team would be guided by the Foxwoods executive.
They would be overseen by you and your
me,
capacity.
Me and my colleagues, correct.
Okay. And I take it, are there members of the tribal council on that executive team?
No, there are not.
Okay.
Mr. Mackey, excuse me, can the Crossroads governance structure, whatever that turns out to be after the new equity is involved, can that board, that entity, fire the enterprise as the contract manager?
Yeah, there are some restrictions on how that would be done, but yes, they could replace the manager, or they could decide to self-manage.
Right.
Okay. Have the creditors in connection with your restructuring expressed views about the current operating model?
About the Foxwoods
Massachusetts
operating model? We've described it to them. We've gone for their approval to make this investment and enter into this. So I haven't had any reaction affirmatively or negatively with regard to it.
In terms of checks and balances on the Foxwoods, Massachusetts Board of Managers, again, yourself and Chairman Butler, Ms. Whipple, how would those work? For example, if the Enterprise Executive Committee determined that the Massachusetts LLC was doing something it didn't like or mismanaging the facility, how would it exercise its control over the local entity?
I would say, as any board would exercise control over any management team, it would, usually the board has oversight. Usually, as an executive that reports to a board, and I've been doing it for a lot of my career, I always view that the executive's role is to advise and to execute. So I report to a board with my best advice. The board makes a decision, and then I execute. So if I tell the tribe, if at Foxwoods the tribal council we should have brown rugs, and they decide they want purple, then I have to go get them great purple rugs. So I would envision that that would be the same case here, and the management team would report to that committee. It would give its best advice and then execute what the committee decided to do.
I'm sorry, I may be missing. You were just now talking about the committee being the three-member
The
committee.
three-member committee, correct.
And if you want, you won't propose to them what color rugs in Massachusetts. You'd propose to the
Well,
Crossroads governance body.
Correct. To the Crossroads governance body, correct. Well, I was giving an example of what I currently do at Foxwoods. So I'm saying that same type of relationship would now exist at Foxwoods, Massachusetts, where we would report to that three-person, with regard to Foxwoods, Massachusetts, would report to that three-person committee and say we'd want brown rugs, and then that three-person committee would
But
give advice.
Foxwoods, the committee only represents the minority share in the governance structure of Crossroads.
But we're majority share, but we're in charge of the operations. So deciding on the color of rugs would be an operational matter.
But deciding on
Selling the property.
selling or borrowing or something like that would be the Crossroads entity would have to come
Yeah,
into that.
there'll be a
Day-to-day operation will be
Yeah,
Foxwoods.
there'll be an operating agreement between Foxwoods and Crossroads, and it'll discuss decision-making, and it'll discuss decision-making that'll be made by the board of Crossroads, and then it'll discuss decision-making that'll be made by the executives running the property. So that'll be defined in an agreement.
Can I just try to see if I understand this? We've got three bodies, actually four, but three bodies you've mentioned most recently. We've got the Foxwoods management team that you report to now, insofar as the
That I'm
Connecticut,
part of, correct.
insofar as the Connecticut operations are concerned.
I'm part of the Foxwoods management team.
All right.
Right.
We've got the Crossroads management team, which is contemplated under this agreement.
Correct.
And we've got the Foxwoods Mass LLC group of three, right?
Correct.
Well, the group of three isn't the LLC. The group of three is the tribal representative in the equity team makeup.
No, in Foxwoods Mass LLC, irrevocable authority for management and oversight has been delegated to a board of managers consisting of Butler, Whipple, and Butera, right?
Right.
Okay. So that's the three I was referring to. That three has oversight over the operational component of this contemplated facility. The color of the rugs, the kinds of machines you're going to get, how many, the spacing of the machines, what kind of lights you have, and all of that rests ultimately in that group of three.
Correct.
And management of the overall facility, economic deployment decisions, what hotels to build, how much to invest in the transportation infrastructure. That all is a decision of Crossroads,
Correct.
right? So that you, Ms. Whipple, and Mr. Butler really are the three ultimate decision makers insofar as operation of the casino is concerned, right?
Correct.
All right, I'll come back to that when it's my turn, but I just wanted to try and see if I understood that correctly.
And just to follow up on that question, with respect to those operational issues, you referenced that there would be oversight nonetheless by the executive committee team down in Connecticut, correct?
Correct.
Okay. Who appoints that executive committee?
The executive committee is appointed by myself. I appointed the members of the executive committee.
I have no further questions.
Okay, Kim.
Great.
If we're going to talk about governance, maybe we can continue, but I was thinking maybe time for a break.
Okay, let's take a quick break and we will pick up then. folks, I think we're ready to reconvene. We had just finished pretty much the presentation from the applicant. Do you have something you want to say?
Just, Mr. Chairman, the way the governance came up through questioning, almost starting at the end and then going back to the beginning, maybe caused some confusion. So, Mr. Butera, if we could just have a minute just to make sure that we're all on the same page here.
Just want to clarify how the governance of Foxwoods, Massachusetts will work. So Foxwoods, Massachusetts, or Crossroads will have its own board that will govern all of the major decision-making of that enterprise. That board will then hire a manager being Foxwoods. So the three-person committee actually, reports up to and is hired by that board. So you have the Foxwoods, Massachusetts, or Crossroads board hires the manager. The manager is governed by the three-person committee, and then that three-person committee hires the executives, such as myself.
And the three-person committee also represents Foxwoods' equity share on the top.
That's correct.
That's correct. That's correct. And it's important to note that this Crossroads ultimately controls everything, the board, because they control the budget. So the scenario with the rugs, the management company can say purple versus brown, but as long as it's within the budget, Crossroads board doesn't care as long as they're working within the budget.
Yeah.
But just to be clear, and Foxwoods LLC may or may not have a member on that board, and that would something that would be negotiated at a later time.
As long as we're talking about this, and whoever's the best person to speak to this, might even be Catherine Blue, is this irrevocable resolution something that we believe is in fact irrevocable? Can another resolution not just come along and say we've got a new way to structure this?
I mean, I would defer to Guy Michael on that question with
Okay.
the tribal expertise.
Can you use the mic, Guy?
Yeah, to answer your question, Chairman, yes, we were satisfied that for purposes of the qualification standards presently, the resolution that was entered into by the Tribal Council of Mashantucket Pequots is irrevocable. It's a delegation to this three-person committee that gives them utter and complete control, independent of the council's authority for the operation of the Massachusetts project. Can a subsequent council pass a resolution that revokes the irrevocability? I suppose legally that's possible, but then the commission would have the authority to say this is not the standard upon which we granted you whatever you ultimately grant them, and be able to revisit this whole issue.
Correct. And Chairman, if I could,
Sure.
To that exact point, correct. At some point, a council could decide to produce a follow-up resolution, as with any legislative body could, but it would put the license at risk, and that's certainly something that the council would take into consideration and not want to do. And with regard to this specific resolution and this action, it clearly assigns responsibilities to myself, the Vice Chairwoman-elect, Crystal Whipple, and Mr. Butera. And in addition to that, we ensured that each councilor, each remaining council member has signed waivers to that effect, that they are not involved in any way, shape, or form with the project.
I'd actually like to pursue this a little bit, unless somebody else has something else in the middle of. So one of, if not, apparently not the, but one of the reasons for this committee structure was to insulate the applicant from the problems that were then going on with some of the tribal council membership. So that they wouldn't be applicants, and I assume also, so they wouldn't be qualifiers, and I assume also sort of to give a level of, to the extent that those various issues, and we'll talk about them specifically, but to the extent that those are substantive, and I'm sure it's debatable how substantive they are, but to the extent that those are substantive, this structure is designed to insulate the applicant from criticism about those problems. Is that correct?
And yeah, I mean, the structure is set up to give us the best opportunity to obtain a license within this jurisdiction, and that's how we approach all jurisdictions that we look at. We've set up different structures for varying jurisdictions and then different enterprises that we've entered into. And that's typical in Indian country, whereby they'll have a governing council and then have different business entities established to address varying needs of the nation itself.
But Chairman Crosby, if I may, I think the structure was more set up to be practical. You know, as I mentioned with the colony capital structure, which it's sort of known as in the business, whereas Colony didn't want to have to go through the process of having all of its limited partners membered, the Mashantucket tribe didn't want to go through the process, obviously, or wouldn't be practicable to go through the process of having all 900+ members of the tribe go through an application process. So that was really why it was set up, was to, you know, limit the amount of people from a practicality standpoint as to who would have to go through the licensing standpoint. You know, I think the criticisms of any member of the tribe or former council would arise regardless of that structure.
Well, I hear that, I guess what I'm a little bit troubled by is to the extent that the independence of that body is crucial, whether it's for cosmetic reasons or simplicity of operation reasons or best practice or whatever, to the extent that that independence is crucial, how independent can they really be, being two of the three elected officials? You know, we're politicians, you know, you're subject to pressures from people on your board, from your, you know, how independent can those people be? If the independence is what really matters here, for whatever the host of reasons is, then why wouldn't they be really independent? Why wouldn't they be outside people, you know, who genuinely do have independent? To say, I mean, I totally trust the good faith. I have no reason not to trust the good faith, but
I can give, I'll turn it over to Chairman Butler, but I can give you my sort of experience, having been there for 3 years. I talked a lot about the restructuring and some of the sacrifices that the tribe had to make. When Foxwoods was in better times, better economic times, Foxwoods, the gaming enterprise, was paying substantial dividends to all the tribal members. It was covering a lot of health care, housing, mortgages, you know, you name it. As part of the restructuring, this council had to go in and cut all of those programs out, cut all of those distributions out. As you can imagine, those were incredibly unpopular decisions, and they made those decisions. So while they are elected officials, I've seen them do things that were in the best interest of the operation, in the long-term best interest of the tribe, but extremely unpopular at the time.
Right. Thank you, Scott. And with regard to being elected officials, that's absolutely correct. But in the sense of our tribal nation, we're elected officials. The way I describe it is we're elected officials. We're members of a board. Where sheep herders, head of a family, and it's amazing the exposure that we have. There's no job like it in the world. I can say that for certainty. And as Mr. Butera pointed out, the exposure that provides us and the experiences that provide us allow us to give substantial insight and direction to this initiative.
And I think there's a little bit of checks and balance that may give you some alleviate some of your concern, in that there's still that Crossroads Board of Governors, that if they're not happy with the decisions that this board makes, can remove them, can fire them. So if they feel they're doing something in the best interest of the tribe.
Yeah, they can't fire the 3-member board, but they can fire
the management.
The management.
Right, sorry, the management, correct.
They could fire Foxwoods.
Foxwoods.
Right.
But
if they felt that the decisions were being in the best interest of the tribe and not necessarily of Crossroads. That's my point.
that would be a big deal.
Certainly. Yeah.
Certainly.
Right.
Okay. Other commissioners, other questions on this general?
Yeah, I have just a couple of questions that tie this back to the incomplete financing. That at the moment, there is about 45% of the financing, equity financing in place, right? 10% roughly from Foxwoods, 35% from Crossroads.
Yeah, I think the percentage...
Whatever the
correct.
split is,
There's
about 45%.
There's a minority amount of funding.
All right.
Correct.
All right. But 55% of equity financing is still being sought.
Correct.
And this structure has been set up by the existing equity participants.
Correct.
What guarantee is there that the new equity participant is going to be content with this structure as opposed to some other structure?
I would say with regard to the structure, we've been in very lengthy discussions, and I think we're very close with either one of two parties. We've gone through the structure with them very thoroughly, so I can represent that the structure, I believe, will remain. Now, in terms of the actual equity splits and how distributions are allocated, that's part of the current negotiation. So
I
that might change.
understand that,
Right.
but in terms of the management structure,
Right. That I believe strongly will remain intact as you see it.
all right. And on top of the equity is another about three times the equity in debt that's being anticipated,
That's
right?
correct.
And what guarantees are there that the lender will be content with this structure?
The lender Deutsche Bank has been involved in this process since I've been involved in it, so since the beginning of the year.
But Deutsche Bank may not be the ultimate lender.
That would be, I would be surprised if that were not the case. I would be surprised if Deutsche Bank did not lead the financing for this, unless a loan is not required.
I'm sorry, I thought I understood you to say one of the alternatives was the sale and leaseback
Correct.
plus a loan
Right.
from the...
Right, so if a loan is required, Deutsche Bank is very likely to be that lender.
Oh, under the sale and leaseback arrangement as well.
Under the sale and leaseback arrangement, there would not be the need for a loan.
There is a
most
loan,
likely.
it's just not a bank loan.
Right, it's not it's a sale leaseback. It's a sale to an enterprise.
I thought then there was additional.
Oh, I'm sorry, there is a loan, but the loan is with the same entity that's
So it
that's
isn't
providing the sale leaseback.
So it's not,
Yeah.
so it's not Deutsche Bank.
That's correct.
So
Alright,
if you
and
pick
so-
one option, Deutsche Bank's
So one
involved,
option
the other
is,
they aren't.
one option is private equity fund, Deutsche Bank.
Right.
Another option is
Right.
one enterprise in a sale leaseback and loan from that same
All
enterprise.
right, and so that's what I thought. And so if you go the sale leaseback route, what guarantee is there that the lender, under that component, is prepared to accept this management structure?
I would say that there's never a guarantee, but we've been in, lengthy discussions with this enterprise. They know our structure. They've given us terms and haven't suggested any change to that structure. So based on all the evidence that I have, I believe the structure would remain intact.
All right, thank you.
I have a question on that point. So you characterize these conversations on these two alternatives as advanced? Is that a fair
I would
statement?
say
or
well
not?
advanced, yes.
Well advanced?
Yes.
Do you have an estimate in terms of timing as a result of that?
What's that?
Timing?
Well, I think that's aggressive, but yeah, I would say within, I would say certainly within a week, but hopefully within days.
And on this same score, sorry. No, go ahead. Just on this same score, so either one of them would create new qualifiers, correct, of some number?
Yes.
And if it's anywhere from 2 or 3 to 5 or 6, I mean, somewhere presumably in that range, what are our time constraints? We don't technically have any rule that says suitability has to be done by X, I don't think.
But we also understand, Mr. Chairman, that if we showed up here with 30, it would never happen. If we showed up with 5, it may not ever happen. And Karen is sitting over there saying 1 may not be able to happen. But there is... Yeah. But I will tell you this. I've as recently as today, have continued to apprise Karen, and there is a scenario there that wouldn't cause her a lot of concern about the timing of it.
Meaning very few, if any, qualifiers.
Correct.
Well, I guess it's a hard question to ask, but
Right.
you presumably, if we chose to permit this to go forward in this way, there is some capacity to get more qualifiers done, but not too much, probably.
Right, and I would just remind the commission, the application was due in January, we're now in November, we've been doing these for 10 months, so when we're talking a matter of weeks before the end of the year,
Right.
I cannot guarantee the completion of that, obviously, and, from our perspective, it has to be thorough and it has to be, be complete.
Right.
And so, you know,
Yeah.
I'm kind of throwing my hands up here because I don't know what to tell you.
Yeah.
And we understand that, and we would expect any condition to reflect that.
Yeah, okay.
I had a couple of questions. Something that was brought out here this morning that I hadn't focused on was the fact that monies from this project in Massachusetts would be owed to creditors on the restructuring in Connecticut. And I had a question, how can we be assured that the operator would make decisions in the best interest of this project and not the overall Foxwoods Connecticut project, because monies are due? And I'm particularly referring to a much better tax rate in Connecticut that would be advantageous, especially in a situation where you owe creditors, to focus customers in Connecticut.
Yeah. Many different elements to answering that question. One, the tax rates are fairly similar. We pay 25% of our slot gaming revenue in taxes.
But zero on table games?
That's correct.
Well,
But
then that's not 25% overall.
Table games have a much lower operating profitability than slot machines. But you're correct. We do not pay taxes on table games. But when you factor in what it costs to operate a table game versus what it costs to operate a slot machine, they're fairly similar. But more importantly, the money that we earn as part of managing the facility in Massachusetts is going to be based on the success of that property. So the more successful that Foxwoods, Massachusetts is, the more money that the gaming enterprise in Connecticut will earn. So it will behoove us to maximize profitability in that market. Furthermore, we have a customer base that we want to satisfy. As I mentioned, the primary decision usually for somebody making decisions to where they want to go game has a lot to do with convenience and location. So our customer base that we're going to cater to that facility is going to want to go to that facility anyway. We're not in the business of adjusting people's wants. So I think there's going to be a strong natural demand from our existing customer base. I actually think you'll see people from Connecticut go to Massachusetts to go see a new product, to go see a new facility. So on the contrary view, I think that we'll be instrumental in bringing customers and revenues to Massachusetts as opposed to taking it from there. But anything we earn will be completely based on the success of that facility.
I also had a question for Mr. Butler, Chairman Butler. You will be influential in this project if successful moving forward here.
Yes.
I just had questions about, on your watch as chairman, an indictment and some other issues with board members. I know you chose to support one of them and pay for those legal defenses. I just wanted to hear more about your decision-making process with regard to these issues.
Okay. Let me just give an overview, and thank you for the question, give an overview of the structure of the tribe itself, and I think that'll help get into the actual concerns. And so the tribe is operated by a governing council, which includes myself as a chair. And again, Councilor Whipple will be the new vice chair in January. There's 7 members of that council, and we're all elected on staggered terms, serving 3-year terms. And as I stated earlier, we oversee all issues regarding the tribe, whether it be government, family, enterprise. Under that, we serve roughly 1,000 tribal members, a community, no different than what you'd see in a municipality or in a state. As you have citizens of that state, we have citizens of the nation. And so as individual citizens make personal decisions that impact them in various legal ways, we are a community that recognizes as a family community, that we recognize that, first they're family members and we need to look after them in that sense. But secondly, we need to understand what they're being accused of, and as a responsible government, and treat that appropriately as well. And so there are 2 issues. One was regarding the former chairman. His issues occurred prior to my becoming chairman, obviously, because he was removed during his chairmanship for unrelated issues to what he was indicted for. But after being removed from the council, by the council, again, which saw in the best interest of the tribe to do so, he was indicted for allegedly, and now convicted of utilizing tribal funds for personal reasons. And so, understanding that, we felt as a council that those accusations were against the tribe, and we could not support that. Right, and so we have a fiduciary responsibility, regardless of being a family member, as a governing body of a nation. We have a fiduciary responsibility to the nation first, and then to the family members second. And in his case, we could not support his claims. And so that has concluded. He actually goes for sentencing, I believe, next week regarding that issue. With regard to the treasurer, Stephen Thomas, his issue, as we understood them, were related to past work performance, going back several years, much longer, to him being on council, prior to him being on council, going back, I think, to 2008, 2007. And so those issues were, in our minds, from the information that we had at that time, were related to employment matters that we had dealt with as a nation, including his termination from his former position, or his forced resignation from his prior position. And so, like any elected body, the constituents have an opportunity to elect who they so choose to serve on the council, and at large the community chose him to serve. Now, during his service on the council, he did an exceptional job, being a member of the council and then being selected internally by the council as the treasurer of the council, and he served as treasurer during one of our most darkest financial times and this very difficult restructuring. And he was instrumental in leading that effort from a community perspective, allowing them to understand what the restructuring meant as a family, and delivering those hard messages, as Mr. Butera related earlier, regarding the declining services being provided by the tribe, and the lack of distributions from the enterprise as well. And so he led that charge. And when we looked at what he was being accused of, we felt that there were issues that we had already dealt with as a nation. And so in that process, I went so far as even sitting down with the U.S. Attorney himself, not Eric Holder, but Laney Brower at the time, and walking through what we felt were the facts from the nation's perspective. They continued to pursue the case. As of about a month and a half ago, the treasurer decided to resign personally and take a plea deal, and his sentencing is scheduled for January. Now, it's unfortunate because, again, we believed in the case facts that this was a prior specific employment issue related to his performance on the job, and that we had dealt with it internally from a procedural perspective.
Another question, something I read in the report. I know in a cost-saving measure, I believe you made the controversial decision to no longer utilize the Connecticut State Police, and that you will now be using tribal police for those responsibilities. I just wondered about the training for the tribal police, and I know that you stated that you thought that they were prepared to handle those responsibilities. What kind of training does the tribal police have?
To clarify that statement, not only do I believe that they're qualified, but the state of Connecticut agrees that they're qualified, because it was a memorandum of understanding that we jointly worked upon with the state, an agreement to allow our officers to essentially become peace officers or are qualified by the state to handle criminal activity on the reservation. And so they're all post-certified in Connecticut. It's a post-certification for their state officers. All of our officers are now post-certified under the guidance of the state of Connecticut, and that is a qualification for them to move forward and handle those criminal matters on the reservation. And so it was a lengthy process. It wasn't so much driven by cost savings. It wasn't driven by cost savings at all. In fact, cost savings was a benefit of that. Because of the cost the state was charging us for regulatory fees related to the state police. The overriding issue there was truly the fact that, one, we're a sovereign nation, and the ability to self-govern, and two, that we had a qualified police force that could enforce laws on the reservation in compliance with our laws and with Connecticut state laws. So it was a collaborative agreement with the state of Connecticut that actually went into effect as of November 1st, where the state of Connecticut has withdrawn their state troopers from the reservation, and we're actively concluding negotiations on a memorandum of understanding.
And from an operating standpoint, I'd just like to clarify, we still have, involvement from the Connecticut State Police when we deem it's necessary. So our police force has a good relationship with the state police, and if we need their services on a moment's notice, we call them and they come in and assist us. So it's not like the Connecticut State Police are no longer involved in the facility.
Right. Any major crime, they intervene.
Thank you. One last question. I see that you've made attempts in other jurisdictions to operate a commercial casino. It has not been successful, correct? Kansas, and you've applied in New York. There's an obvious difference between tribal gaming and commercial gaming. Do you anticipate issues around operating a commercial casino if granted a license?
I don't foresee any issues. Those issues related to those specific projects, and we've had a project out in California that was a tribal gaming project, but our perspective was that it was commercial gaming. When you looked at the timing of those projects, all those projects were horribly impacted by the broader economy, the lack of financing that was related to the financial markets in 2008. When you look today at the Kansas project, it is one of the most successful projects in the country from a return on investment perspective. The competing project in Philadelphia, Sugar House, is doing very well, and now Pennsylvania is reopening. They're going through the licensing process of the second Philadelphia project, which was originally our license. So both on paper were fantastic projects. We had solid management teams put in place. It literally came down to financing at that time, and it was just the worst market timing that you could have seen anywhere. At that time, financing for any new construction project, regardless of the economics, was not getting approved anywhere in the country.
Thank you.
Thank you.
A couple of quick follow-up questions to Commissioner Cameron's questions. First of all, in terms of, I understand you have a proposal that was just approved in New York State following a referendum last week, is that correct?
We are applying for a casino license in New York State, that's correct.
Okay.
And there was a bill that was just voted affirmatively.
A week ago, right?
Correct.
Okay.
Allowing for those licenses to go forward.
And your project, I think it's in the Catskills. Can you give a quick overview of your role in that project?
Yeah,
perhaps even the financing piece of it.
Sure, it'd be very similar to what's being proposed here. We would be a minority equity partner, developer, manager of that facility. It's contemplated that facility is going to be, although similar in style, quite a bit smaller than what we're proposing here. It's probably going to be a $500 million facility, but it'll be a fully integrated, resort casino with restaurants, hotel rooms, and entertainment facilities in the Catskills.
Okay. As CEO, you're managing, for lack of a better term, reorganization, turnaround at your facility in Connecticut. You're potentially managing a $1 billion plus project, potentially in Massachusetts, and now an additional project in New York State. How do you, as CEO, undertake that responsibility of keeping these three projects all in the air at the same time?
It's always challenging, but I've been involved in situations like that in the past. Previously, I was the CEO of a company called Tropicana Resorts, where we operated 10 facilities. I was CEO of Trump Resorts in Atlantic City, where we operated 3 very large facilities and actually a fourth riverboat. I have a good management team. We do hire up and staff accordingly, so I do have, property managers that control a lot of the day-to-day and report up to me. But, like any other CEO, it's obviously, a lot of hours and a lot of meetings, but we wouldn't take something on that we didn't feel we could handle. One of the reasons we like Massachusetts and the Catskills is they're both very proximate to Foxwoods, so it's something we thought we could handle. You know, we wouldn't be looking at something in Las Vegas or China or, you know, something like that at this point. So we only take on things that we feel as though we're capable of handling. And I will say that most of the operational turnaround at Foxwoods is now complete, having been working on it for 3 some odd years now.
Okay. And is there a status on the financing for the project in the Catskills?
We're
that
much
you can
earlier
share?
on in that project, so we are in the process of securing financing for that right now. But it's at an earlier stage than where we are here.
Okay. Chairman Butler, one question kind of following up on Commissioner Cameron's line of questionings with respect to Mr. Stevens. As I understand, the Tribal Council appointed him as treasurer, and it sounds from your testimony had a pretty substantial role as you've negotiated some of this financial restructuring. It would just appear to me that you have a gentleman serving as treasurer who's obviously, there's a question of misuse of funds. You get a letter in May, or he receives a letter in May from the U.S. Department of Interior essentially saying, we don't feel entering in any contracts with this individual. And he continues to serve, I guess, all the way up through October. Was there a discussion at any point of, you know, obviously you're an elected member of the council, you don't need to leave the council, but could you step back from your responsibilities as treasurer? These are all financial charges and financial matters that were being alleged against him at the time. Was there any consideration saying, step back from that position until some of these issues can be resolved?
There were discussions, and again, we understood the case, the facts of the case, as I had stated earlier, and we felt comfortable with that position. We did spend time not only with our vendors and our creditors explaining the position, and they all concurred. We also spent a lot of time working with Department of Interior and Department of Justice with regard to contracts and grants as they issued that letter. And they ultimately agreed as well that we had satisfied the structure, that he wasn't engaged, similar to the structure that we set up for Massachusetts, whereby the other councils aren't engaged in decisions regarding Massachusetts.
Okay. Thank you.
Can I just follow up on that? Because I recognize that structure is in place, and I recognize why it's in place, and I recognize that the insulation of the other tribal members, and you've described that well. On the other hand, there is a question. You and Ms. Whipple are 2/3 of the team that ultimately will make the decisions for Foxwoods Mass. And so some part of the thinking is important to me. Mr. Stephen Thomas was basically accused, in the government's view, of having a $200,000 a year no-show job, right? I mean, when you boil it down, that's what the accusation was.
Correct.
And how was it that you processed the notion that it was something the tribe had dealt with, that he was that made the council okay with supporting that accusation? Was it that the facts were wrong, that he actually showed up every day and he earned his money? Was it something else that led you and the council to support it?
And just on that issue, again, the facts that we had and our opinion on that were that, again, it was a job that he wasn't performing well at. We didn't have any evidence that he was. I'm sorry, I apologize. That he wasn't performing well at. We didn't have any indications from. We do annual performance reports on all of our employees. We didn't have any indications from a reporting perspective that he wasn't performing, and so based on the information that we had, again, we felt comfortable in his current standing.
That he had in fact been showing up and performing his job.
Well, no, that in that position as an underperforming position, we had later dealt with that at that time in 2008 by terminating his position.
But he had collected some $700,000 for a job he hadn't performed.
That is what the government was alleging, yes.
Did the tribe conclude that accusation was correct or incorrect?
No, we didn't.
You didn't,
We didn't conclude that it was correct.
you concluded that it was incorrect.
We concluded that he wasn't the best performing employee, and that we had, as we deal with any underperforming employees, we terminate their positions, and that's how we resolve the situation.
So to simplify, he was showing up, he just wasn't performing at the best level. While the government took that as more of a no-show, the tribal council took it as the right to terminate his position.
The tribal council, as I understand it, is the hiring authority for tribal positions.
No.
Who is the hiring authority?
We have, so we're structured in three forms, actually. We have regulatory bodies, we have the gaming enterprise, and then the non-gaming enterprises, and then the government. Within the government itself, we have different departments, and those department directors can hire and fire. They work, we have a fairly well laid out human resource department and policies and procedures, and there's a policy that they follow, that they put out the job for bid, they get a list of qualifying applicants, and then the director will decide who is employed. Now, from the council's perspective, we hire on the government the key individuals. So we hire the CFO, the chief of staff, the legal counsel, and some of the key administration. But there's too many ongoing daily occurrences for the council to be involved at that level when we're acting in a board capacity.
So you hire the chief of staff?
Correct.
And the current chief of staff is Anthony Beltran?
Correct.
And what are there any criteria for employment insofar as criminal records are concerned?
Not in the government positions. There are certain federal laws that relate to employment and background, and if they're working with in certain areas regarding children. But outside of that, there aren't any specific regulatory requirements for government positions.
But at the enterprise, there certainly are.
Right, and it's completely separate and distinct.
Well, I know, but I'm now trying to understand. I'm trying to understand some of the decision-making at the tribal level, and not at the tribal level, at your level, Mr. Butler, your level potentially, and Ms. Whipple's, because you, as I said, are the ultimate decision makers for Foxwoods, Mass. Mr. Beltran was convicted of at least 2 felonies, right? And why isn't that something that is taken into account before he's put in charge of the police and the fire and the safety and other kinds of components of the tribal government?
Well, it certainly is, but what's also taken into consideration is our history with him, and that was prior to his returning back to the tribe. And some of the history of the tribe is, when you go back this year we not celebrated, but recognize the 375th year of the Treaty of Hartford. The Treaty of Hartford basically said that Pequots no longer exist, they can't speak their language, and everyone was sent off into slavery. And so for the last 375 years, we've been fighting for our identity and to get our lands back and to hold on to what we had. During that time frame, as you can imagine, there was very little in the means of economic activity to keep family members and citizens at Mashantucket. And so over time, more and more people dispersed from the reservation, Tony and his family being one of those. And so many ended up in the westerly area, Providence, Boston, New York. Tony himself, I believe, ended up, his family located out in the California region. And so, having those intergenerational wounds, as they say, and knowing our history, there were some troubled family members early on. And when we had the economic success we did, one of the key initiatives we had was repatriating and bringing people back to the reservation, Tony among many of them. And so when they came back, we had opportunities for folks that they had never seen in their lifetime. And they were positive opportunities. And the point of it was to try to change people's lives, get them re-engaged in the community, get them to give back to the community. And I look at Tony as one of the success stories of that. He came back to the community, understanding his past prior to, came back to the community, was a contributing member of not only of the nation, but in the employment arena as well. worked his way up to get elected as a council member, and then following that served as the head of our Public Works Department, and then worked in several council offices. And prior to him being chief of staff, he was the executive assistant to the current vice chairwoman, and doing a fantastic job working with the council. And so he showed this innate leadership ability that you can't teach, and he has this ability to interact with the departments and provide the guidance on behalf of the council that we needed to move things forward. And I would attest the movement in the policing bill and the commitment from the state of Connecticut to work with us on the policing, to some of his management style and being able to focus on the task at hand and get it done. And that gave us confidence in his ability to be chief of staff. Now, and again, just to reiterate, the chief of staff position is simply over government operations and has no interaction or relevance with the gaming.
I understand. Okay, thank you.
Thank you.
Others?
I had a couple of questions of Mr. Nunes.
Excuse me, are we, you're going to do?
Sorry. Oh, I'm sorry. I didn't know.
There
Were
are
you
others.
complete?
Just a few questions.
Oh,
of,
okay. I'll let you go
Chairman
first then.
Butler and.
Sure. I'm sorry.
Just to pursue very briefly.
Attorney, I just have one more kind of business-related question for Mr. Patera. You know, part of your agreement was to reasonably assist, correct me if I have this wrong, reasonably assist Crossroads in securing the additional financing. Do you think you've played an equal role in doing that, or a larger role in doing that in terms of reasonably assisting Crossroads?
I think we've played a very large role in doing that. We've been involved in all the necessary steps to get to the point where we could raise financing. We've been involved in all of the negotiations. Unfortunately, equity isn't something you go into a store and buy. We ran a very, lengthy and robust process. We talked to probably over 50 candidates. We narrowed it down to 2, so we've been very involved, as have the other Crossroads partners.
You finished?
Sorry, go ahead.
No, I've got some too. We have a couple of letters from Representative Dykema, and there were a couple of issues that she raised that I wanted to ask about. Forgive me if this is explained in the hundreds of pages, but she talks about the town of Ledyard being owed $300,000, either was owed or is owed. That is in dispute, and she suggests that's evidence of not a very good relationship with your host and surrounding communities. What are the facts there?
I can speak to that. We actually have a fantastic relationship with the town of Ledyard. That's a primary school system for our students at Mashantucket. I know the mayor, John Rodolico, extremely well. He's a great guy. And we are the largest taxpayer in the town of Ledyard as well. And so the issue at hand with regard to this concern is how there's specific tax treatments with regarding slot machines in our gaming floors in Mashantucket. And Ledyard is asserting a claim that they have the ability to tax some of these machines, and that's the tax that's at issue, not so much us owing taxes to the town. We did appeal that claim up to the Second Circuit Court of Appeals. That claim was denied by the Second Circuit, and we're currently paying those taxes to the town of Ledyard.
Okay.
Those are excise taxes,
They're
basically.
not taxes owed by the tribe, they're owned by the slot machine manufacturers who lease those machines to the tribe. See?
Yeah. And there aren't other unpaid back taxes and disputed fees and so forth?
Nothing owed from the tribe to Ledyard.
Okay. I wanted to ask a question about this alleged exaggeration about the I-495 intersection. Or is that coming up someplace else, or can I go ahead and?
I had mentioned that to the applicant. They had submitted a written response, but I had indicated at the hearing they should address that, so they could do
Okay,
that now.
because we also, we've heard this several places, but Representative Dykema also wrote this and sent us some information. We actually did hear a presentation too, where we heard characterizations of the interchange, and I wonder if you could react to that criticism.
Yeah,
The suggestion was that you dramatically exaggerated, both to the people of Milford and, by the way, to us, the status of that, particularly with respect to Federal Highway.
Yeah.
What's going on there?
Understood. And I think we provided the commission with a 2 or 3 page, Sean Reardon, our engineer, went over that in great depth. We've actually, I've sat in on every conversation, or most every conversation with MassDOT as well as Federal Highway. We've been very clear to say that a project hasn't been approved, because we can't say a project hasn't been approved because we're not at that stage yet. I think I was really troubled by Representative Dykeman's letter, because I really think when you break it down, it's semantics. The issue really comes down to the word interchange versus the word collector-distributor road. And I think they were talking on a technical level that we use the word interchange versus collector-distributor road. And our goal here is to have a collector-distributor road that will feed from one exit for two straight exits. And it won't be a new interchange, it'll be a new collector-distributor road. And the collector-distributor road is consistent with what we've been saying at MassDOT, consistent with what we've been saying at Mass Highway, consistent with what we've been saying to you and to the town. And I think if you really look at the letter, the correspondence clearly indicates that they understand that this is the road we're going in. So
they understand? That
MassDOT and Federal Highway understand that that's the way we're going, but not a new interchange. And we're not representing that, and that's not the direction we're going in. So I think, Mr. Chairman, it was a matter of semantics. And, you know, while I provided you with a 2 or 3 page letter, it really just came down to that. I think it was as simple as that. And I'm glad to have more conversation with the representative if she thinks we're unclear. But I think we've been very, very clear. MassDOT asked us to make it clear, and Federal Highway asked us to make it clear. And the main thing was, don't say that you have a project approved.
Well, but the brochure, the flyer, or the ad that she sent to us has a sentence that says, the host community agreement requires that Foxwoods, Mass. Will implement and fund all on-off-site traffic improvements, including, and the first bullet point is, a new highway interchange from I-495 to Route 16.
Right.
And I guess what you're saying is it's not an interchange, it's something else.
It's really a collector-distributor road that
Has it never,
collects.
have you even proposed a new interchange?
No.
So, but what you're saying is this was not done with malicious
No.
intent? You just used the wrong word?
That's correct.
Because an interchange to me is an interchange. It's not a collector-distributor road.
And in hindsight, you know, you have your folks on the ground that are sending out those pamphlets. They run by us, and I take the responsibility for missing that. I guess collector road and distributor wasn't.
Okay.
I wasn't.
Well,
thinking.
it's non-trivial because it came to us as well. I thought you were talking about a new interchange when you made your presentation to us. And there's a referendum on the 19th, which it seems to me it's legit that the people should know what you're proposing and what you're not. And,
we've made it very clear through many, many presentations exactly what we're proposing here. And actually, Mr. Chairman, it was Federal Highway that suggested this, because the current 495, the exits between the current 495 currently don't meet the federal guidelines. So by us doing this, they will actually make those in compliance. So they were pushing us in this direction. Not that they've approved it, but they thought this was a better solution because it now puts something that's not in compliance into compliance.
Okay. Go ahead, sure.
On this same line, have you seen the email from Michelle Daigle, dated September 30th on this subject?
I don't know that I have. If I have, I don't recall it.
Well, let me just read it.
Sure.
And then we can put it in the record if there's no objection. This is a reply to an email by Ms. Marcy Setter. And it says, Dear Ms. Setter, thank you for your September 23 email to Federal Highway FHWA, whatever that is. MassDOT and FHWA have been briefed by the developers of the proposed casino project in Milford regarding access to the casino site adjacent to I-95. MassDOT and FHWA have advised the developers that based on the current design standards, a new highway interchange in this area is not warranted. Instead, the developers are designing a new local collector-distributor road system between the existing interchange and ramps at routes 85 and 16. to accommodate additional traffic. A new interchange has not been proposed or approved at this time. MassDOT and FHWA are committed to ensuring that the interstate system is safe and fully operational, and any proposed changes will require significant review and approval at various stages during the design process. There is state legislation regarding the location and development of casinos in Massachusetts with established conditions and timelines that have to be followed. I'd encourage you to work with your state and local representatives. So that, in essence, is, and that's signed by Michelle Daigle, Area Engineer, District 3.
I
So
have
that's-
seen now that you've read that. Yeah.
That's consistent with what you just said.
That's correct. And I would appreciate that being put in as an exhibit if the commission's so inclined. I think that clarifies my point.
Just to make sure about one thing, when you or whoever hired, let's see now, which one was it? Mr. No, you're Mr. Butler. The chief of staff. Beltran, yeah, the baseball player, right. When you hired him, were you fully aware of his criminal record in the past?
Yes.
So, and that was something which was consciously in your thought process? You judged, you knew it, you judged that he'd done his time, he was rehabilitated, but it was a weighing process that was a part of your...
Yes, and it wasn't something that was taken lightly. I mean, we deliberated, exactly this specific issue, not as it relates to Massachusetts gaming, but just the public perception itself, and we felt confident in his ability that we would overcome that.
Okay. Did you have other questions?
Just a few questions for Chairman Butler to follow up on those two issues. First, back to Stephen Thomas for just a minute. I understand he was elected to the council in 2010. It's an elected position, so there's really no way to do a background investigation in connection with that. And then in 2012, he was appointed as treasurer, correct?
Yeah, I believe so, yes.
Okay. How do you... Is that an appointment made by the chair, or is it made by the rest of the council?
It's made collectively by the council. So the chair and the vice chair position and at-large council members are elected by the citizens, and then the two remaining officer positions, the secretary and treasurer, are elected internally by the 7 council members.
Okay. And is there any due diligence process before the council makes appointment of these executive positions?
I mean, due diligence in the sense that we've grown up together, we've known each other, we understand, their strengths and weaknesses, and amongst the counselors that were eligible for a treasurer, he well exceeded what was necessary to fulfill the position.
Was the council aware at the time it appointed him treasurer that he had declared personal bankruptcy 2 years previously?
Yes.
And the council was presumably aware that at the time he declared personal bankruptcy, he was making a substantial salary?
Yeah, correct.
Okay. Tell me how the council assessed that personal bankruptcy in connection with his appointment as treasurer. Did it enter into it? Did it affect it? Did anyone say, hey, there might be an appearance issue here?
Yeah, no, it's certainly part of the conversation and brought up to his credit by he himself. And so he brought up the issue to the council saying this is something that may be a reflection on me publicly, but understanding the circumstances surrounding it, again, we felt comfortable in his ability to be treasurer.
Okay. Now, in connection with these executive positions like treasurer, I understand that when you're elected to the council, you can't simply tell somebody to step aside, but could the council have removed him as treasurer?
Yes.
Okay. And it determined not to do that even pending this federal indictment we've been talking about? Okay. And again, on that issue, was there discussion? I understand that part of the thinking was the council felt that he was not going to be found guilty of the charges he faced. But did the appearance issue come up in discussions at the council level?
Oh, absolutely, absolutely. And again, me personally, as chairman, interacting with the various government agencies, Mr. Butera on behalf of the enterprise, speaking with vendors, myself going up to U.S. departments. And I mean, there certainly was an appearance concern that we were well aware of and we heavily debated. But again, our confidence in the outcome at that time, which ultimately led to a plea deal, which wasn't what we expected, but at that time, we felt comfortable with his remaining treasurer.
Okay. Michael Thomas, just to switch gears for a second, he, as I understand it, was indicted on the same day as his brother Stephen.
Correct.
And he, at the time of that indictment, he was no longer on the tribal council. He had
Been removed.
He'd stepped off in 2009.
He was removed from council in 2009.
Okay. And as I understand it, he was indicted in 2013 for the theft of more than $100,000 in tribal funds while he was chairman from, I think, 2007 to 2009, thereabouts.
Yes.
Okay. After the indictment, did the tribe do any independent investigation into the charges against Michael?
No, we, again, being a federal case and being a separate claim from what they were claiming against the current treasurer, we left it into the hands of the federal authorities. We cooperated with them willingly to allow them to come to their conclusions. And so we essentially turned it over to the federal authorities.
Well, did the tribal council or did you as chair, Mr. Butler, direct that at least someone look into how Michael could have done this without anybody noticing?
We did. We went through our records, and we quite frankly couldn't find anything within our records because the case revolved around records that weren't necessarily filed.
Wait a minute, say that again?
With regard to his case, what they were looking into were specifically were expense reports and his non-accounting for those. But from our internal accounting perspective, those expense reports were not filed with our finance, and so we weren't even aware of what was or wasn't being paid for.
Does that mean that he was neglecting your rules relative to or your standards relative to expense reports?
Yes, correct.
So the net of that, what happened? I mean, somebody dropped the ball on that, right?
There was, I mean, the way that we looked at it, there were many people that dropped the ball on that, and currently the former chairman is paying the price for that.
And what have you done to address that?
We've, as any young government, we're evolving, right? And so as I spoke earlier about repatriation and building this government in the last 25, 30 years, this October was our 30th recognition of 30th anniversary of federal recognition. And so, you know, with any young government, we look at best practices, and as we see practices that need to be addressed, we address those. And so with regard to expense reporting, we've tightened up the windows as far as when expense reports have to be submitted. We've been tightened up the reimbursement policies. We've tightened up in his specific case. It was with regard to a corporate credit card. We've eliminated the existence of corporate credit cards across the organization. And so as we come across new challenges, we amend our policies to reflect that.
One other, I think very few of us, certainly I, don't really appreciate the structure that you have. I mean, it's contrary to our experience, and you know, understand when you talk about a family and you think back, well, that now that you think back about original Indian tribes, you can sort of see where that comes from, but it's a structure which we're not familiar with. And a lot of people, including you, are working to try to figure out how do you make this work, and I understand that. But in a comparable structure where there is a business entity, you're like a sovereign fund, you know, which is an odd structure, but there is a compliance committee that has a specific role. And we've talked to a lot of applicants about this compliance role and how is it handled. And I've said that I think it's important that people have somebody in their organization who are empowered to be the skunk at the garden party, who can ask the hard questions, who can challenge the chair's judgment about a Thomas or a Beltran or whoever. I don't remember reading your structure that either your corporate entity or the enterprise entity have a compliance committee.
Yeah.
And I'd like to know how that function is fulfilled.
Yeah, I can address that. First of all, we are a regulated entity. We have a compliance committee. We have internal audit.
This is the enterprise?
This is the enterprise. The enterprise has, I will say, having worked at many organizations, has this comprehensive a compliance and regulatory environment as I've ever operated in, so much so that it, in fact, hinders our operations from time to time. But we are fully staffed. Our regulations follow regulations of other jurisdictions, like Atlantic City. It would probably be the most relevant jurisdiction that we follow. Everything is done in compliance with the state and our compact with the state, and all of our operations are thoroughly vetted through that compliance committee, and anything that we do financially is thoroughly vetted through our internal audit. We also, as I mentioned, have public debt, public indebtedness. So we report as any SEC filer would report. One of the things that we agreed to in part of our restructuring is we would do everything that a SEC filer would do. So we will publish things that are akin to 10Ks, 10Qs. We have analyst conference calls. We have investor meetings. Everything is done through our external, we have an external auditor that issues audit reports. As part of their audit report, they have to do a fraud audit. They have to meet with our compliance committee. They have to meet with our internal audit. This is a Big Four accounting firm, and we've gotten favorable reports both while we were in and out of restructuring mode.
And who's on the compliance committee?
I don't know the specific members. I'd have to get back to you with that, but it's a committee of individuals that report directly up to the enterprise management.
Who appoints them?
I don't know off the top of my head.
If this is so robust,
yeah,
and you don't know who the people are, and you don't know who appoints them?
The internal audit reports to the
right. No, I'm talking about
the tribal council.
I'm talking about the compliance.
And the compliance committee would report to the executive committee.
What executive committee?
Which would be myself and my 7
But you don't know
colleagues.
who is on it, and you don't know who appoints them.
Yeah, off the top of my head, I don't. I can't. They report to our chief. They spend most of our time with our chief financial officer and our treasurer. So I apologize.
Well, it's not a matter of apology. But it just seems odd. I mean,
I would say most of when I say compliance, most of it is done, and maybe I misspoke. Most of it is done through our regulatory environment and our regulators. So that's who I'm really referring to. And that would report to the council.
Well, then maybe you didn't get what I was talking about, because it does seem to me, particularly with respect to the enterprise, and the tribe's business is the tribe's business, so I happen to think it's an interesting model for other reasons. We have inspector generals, but forget that. For relative to the enterprise, the compliance committee is meant to be a bunch of relatively independent. I oftentimes think they're not as independent as they should be. I think that's a real problem in most of the compliance structures that we've looked at.
Right.
But they're meant to be an independent group of people of some authority and some maturity and some force,
right,
whose job is to cleanse and pass the sniff test and double check the judgment of the senior most people, most particularly in this case yourself.
Right.
And you want somebody there, I would think.
Right.
So.
And that function is handled through our regulatory bodies and our internal audit. And then within our finance function, we have compliance officers, so who report to our finance department.
Who are the regulatory bodies? Maybe
We have a separate and independent gaming commission, which is separate from the gaming enterprise itself. They're appointed by the tribal council, the commissioners. Our lead commissioner, our chair, is a gentleman by the name of George Henningsen. He's been in the gaming industry, helped write the regulations for New Jersey. And when we entered gaming 25 years ago, we wanted to be at the peak of compliance. We wanted the tightest protocols in place, and so we hired the best at the time and modeled ourselves after New Jersey at that time, which was the strictest regulations in the country, and we made ours even stricter. And so when you look at Indian gaming, this is more for educational purposes, we are the most regulated members of the gaming industry. So we not only have internal regulations with our gaming commission, We're also regulated by the NIGC, which is the National Indian Gaming Commission, as well as through our compact, we report to the state. So the state reviews and approves our key license holders as well. So we have multiple checkpoints from a regulatory and oversight perspective.
To follow up on that, as I understand it, the Gaming Commission right now is entering into a process of creating a background check system for non-gaming employees.
Mm-hmm. We actually...
Not your dealers, et cetera, on the property, but
yeah,
hotel staff, et cetera. I mean, having been in business for so long, can you kind of share with me why at this moment? Was there an event or something that triggered a decision to kind of go in this path with respect to non-gaming employees?
No, that was one of those things where the commission itself, they continually review the regulations and look for best practices. In an instance in one of the other jurisdictions, they were licensing non-gaming employees. We actually approved that several years ago, and recently have removed that as a component of licensing. So we no longer license non-gaming employees, but we did attempt that for a few years, as that's one of the procedures that Mr. Butero was referring to earlier, that overcomplicated operations as opposed to easing operations, and we've since removed that authority from the Gaming Commission.
We also operate under very strict standard operating measures, SOMs, which would mirror any other regulated jurisdiction. So we have our SOMs, our regulators ensure compliance with our SOMs, our internal audit ensures compliance, and then we have compliance officers that work for our team that if there are problems will self-report to those entities so that we are proactively identifying any problems.
Mr. Chairman, I just have...
Could I, before you're going to launch, can I go back to something I was talking about a minute ago? Because I had this exchange with you about the letter from, the email from MassDOT, which said that you're not proposing an interchange, you're proposing a collector-distributor road system between the existing interchanges and ramps at routes 85 and 16.
Correct.
But where is that shown on this slide that you presented to us today?
It's actually shown between, it's the widening of the road, the widening of the 495.
But this document, this slide you presented to us today, has a label that says new interchange to Route 16, and Route 85 isn't even on it.
No.
You want to take a look at it?
Sure. Do you mind if I bring up our engineer who can speak much more articulately?
Well, I'm really
yeah, well, it's in yellow there. That's a tough one to look at. There's two different things. There's an interchange that will lead to Route 16, but
I'm really, and I'd love to hear from the
Yeah.
engineer, but I'm really interested in the presentation. And because it does say, and we were talking about whether it's semantics or something else, it does say here, new interchange to Route 16, and then there is a cross-hatching right there.
That's correct.
Yeah.
That's correct.
And is that meant to be an interchange?
That's correct.
But you're not proposing an interchange?
No, yeah.
Why don't you come up and use a mic? Point, Judge.
You don't want a lawyer talking engineers.
I'm Sean Reardon with Tetra Tech. We're the engineers that help develop these solutions. So in an engineering profession, an interchange is a very specific highway improvement. It's traditionally you could identify it as where a crossing roadway connects with a highway, usually indicated by a series of on-ramps and off-ramps, and that's it. So when you're speaking about an interchange, it refers to a very kind of local improvement, so a more narrower solution than what we're proposing here.
Wait a second, I'm sorry. The interchange you just described of crossing roads with, that is what you would typically mean by interchange.
Right, and it's limited. It's limited to the connection of one roadway with another roadway.
Right, okay.
So in this situation, an interchange would be like the existing highway connection between 85 and 495, or the existing highway connection between 109 and 495.
Right.
What we're proposing here, we can't do just an interchange, because as the attorney suggested, the spacing is too close. So an interchange is not an appropriate solution. What we've used is the word interchange to effectively generally refer to the connection of Route 16 to 495, which currently doesn't exist. The way we're doing that is by constructing a collector-distributor road. Chairman McHugh, Commissioner McHugh, that is about a 3.5 mile widening that connects the three intersections together. So in effect, there is no interchange from 16 to 495 because we're connecting to the collector-distributor road, not directly from Route 16 to 495. So it is a question of language that we use. We had a real hard time with the public communicating the concept of a collector-distributor road. When everybody identifies it, we're affecting a new connection between Route 16 and 495 that currently doesn't exist, referring it to as an interchange because people, I think, universally understand the term interchange versus collector-distributor road.
But I understand that.
Can we put up this picture? No, I just want to have them put that slide up. I mean, it was in that little presentation you made. If you could just get that slide up so we could.
The slide on top.
We got a
Here he
techie.
comes.
We got a techie coming up.
Here we go.
Sorry if I messed it up.
With much anticipation, nothing has happened.
There it is.
We're getting, Eric.
And Mr. Engineer, here's a pointer if you need it. A little button.
So I think when people think of a new interchange, they think of...
Can you make that full screen? Oh, okay.
When we think of a new interchange...
Can you grab a mic off one of those things?
In general terms, we think of one highway or roadway connecting to another roadway. So what this is a situation where we've got two interchanges. Exit 19 would be termed as a traditional interchange. Exit 20, traditional interchange, a series of on-ramps and off-ramps. So as the attorney mentioned, as Mr. Allen mentioned, this is currently 1.9 miles apart. So substandard spacing. So we couldn't just introduce another standard interchange at this location. Much cheaper to do that, much less expensive for us to effect as a solution. But it would make it more complicated, it would make it less safe. So instead, what we have to do is combine these three intersections, or these three interchanges. Again, I'm using the term interchange as a general term, speaking as a connection from one highway to another. Combine these three interchanges into one offline highway system. So what happens is these three interchanges are now connected separate from the main line, and then they join all together and then either enter at this side and exit at this side, all at one location. So in effect, it becomes a new system, not an interchange, a collector-distributor road. Far more expensive than just a single interchange. And this was a very important point from a federal highway standpoint. In our earlier discussions, we had a far more limited infrastructure solution. They came back and said, no, you can't just do a standard interchange. You have to do a collector-distributor road.
So in effect, you would exit at exit 20, you'd exit 495 at either 19 or 20, depending which way you're coming.
Correct.
You'd get onto what I might call a service road.
Correct.
And run alongside 495 until you get to this new connector.
Correct.
Okay.
And that's exactly what
What's
was
that crossover line?
That's an overpass to connect the northbound and southbound lanes to the new connection.
Okay.
So really what happens is right now Route 16 has no connection to the highway system. And with federal highway regulations, we can't, there's no allowance for a direct ramp to a private development site or anything like that. So we have to connect to a local roadway or a highway, a state-controlled roadway. 16 provides us that opportunity to do it in a safe manner and effective manner that creates a net improvement on the highway system versus creates new issues. We have to construct a collector-distributor road, which is far more comprehensive than just a traditional interchange.
But that collector-distributor road is not shown on this document.
It is. It's essentially, the yellow is creation of new lanes. Gray is existing lanes. So in order to create the collector-distributor road, we're building additional lanes along that full length that you see there to effectively create that new offline roadway or surface road, as the chairman referenced. So it mimics, it's coincident with the existing lanes.
So you could get on at exit 19, drive the collector-distributor road all the way up to exit 20, or get off at exit 16 or come into the complex.
That's a good example. So if I wanted to get from Route 109 to Route 85, right now I could get on the highway, I'd have to merge with the mainline traffic, then get off at exit 20. In this situation, we get on the collector-distributor road, stay on the collector-distributor road, and get off at exit 20 without ever having to get onto 495.
Okay. I understand that now. I do think this is, I can understand where the confusion comes in. I think this is hard to follow.
And that's, Attorney Allen took the blame for that, but that's, our use of the word interchange was just a decision to help communicate the idea of a new connection.
Yeah, I understand that, but the existence of these roads and this whole scheme is a subtlety I didn't pick up at all. On this.
And you know, one of the
I
things...
suspect most people wouldn't either.
Well, one of the things, Commissioner McHugh, is we provided with an overview. When we were in these meetings, there was a much more blown-up detailed plan that actually showed the lanes, showed the distributor, showed the set of lights of how you cross over 495.
Okay.
So we got into much more into the details than we did here today, because we're really here for suitability.
I
But
understand
should
that.
we get to the next level, we'll certainly provide the commission with a lot more to give you more comfort.
I understand. Okay, thank you.
Mr. Chairman, just a couple of additional items that I'd like to get into the record via questions to Chairman Butler, if that's okay. Back to Anthony Beltran for just a minute. I understand that he was elected to the tribal council back in 1998. Correct. And again, no background checks there. It's an elected position, and so that's that. But then it's how long was he on the tribal council?
One term, 3 years.
Just 1 term. Okay. And then at some point after that, he was appointed chief of staff.
After other employment, yes.
Okay. What was the year he was appointed chief of staff?
Chief was this year.
Oh, just this year?
Yeah, just this year.
Okay, so during your chairmanship?
Yes.
Okay. And I take it from earlier questions from the commission that there was a due diligence effort undertaken before he was appointed chief of staff.
We actually did a internal posting and had several applicants.
Okay. But before Mr. Beltran was hired, did someone associated with the tribal council take a careful look at his background?
Yes.
Okay. And how was that done?
Knowing him as a family member, we fully understood what his background was.
Okay.
And so we had a healthy dialogue amongst the council regarding that.
Now, as I understand it, and as reflected in the suitability report, this chief of staff position that Mr. Beltran was just appointed to this year oversees the police department?
Correct. All public safety.
The fire department?
Correct.
Emergency services? Public affairs?
Yes.
Museum?
Yes.
And all public works?
Yes.
Okay. And so when you made this decision to appoint Mr. Beltran to these positions overseeing these various departments, it sounds like from earlier questions you were aware that he had a prior felony background, correct?
Yes.
Were you aware of the specifics of the felonies that Mr. Beltran committed?
Yes.
And you were aware of the sentences that he served in connection with those felonies?
I wasn't fully aware of the sentences, but I was aware that he did serve time, yes.
Okay. Let me just ask you briefly if you could turn to Bureau Exhibit number 16. This is Chairman Butler, just for the record. It's an article that was published in the Hartford Courant in 1998 by an investigative reporter named Lynn Bixby, detailing in quite some extent Mr. Beltran's background. Do you recall if, when you made the decision, when the tribal council made the decision to appoint Mr. Beltran to this position, it was aware of the existence of this article?
Not the specific article, no.
It was not.
No, but it outlines his background, so.
Okay. And you're saying that you, in your it is your recollection that the tribal council was aware of the details of the various criminal offenses that Mr. Beltran committed before he was appointed to this position?
Yes.
Has there been any effort to determine whether Mr. Beltran has ever been arrested for other offenses other than those offenses for which he's been convicted?
Not that I'm aware of, no.
Not that you're aware of that he has been arrested?
No, we haven't. I'm not aware of him in any other arrests, and we haven't done any other background check on him because, again, it wasn't required for that position.
Okay.
And again, just when this appointment to the position of chief of staff, overseeing the departments that it oversees, was made by the tribal council, did anybody on the tribal council express the view that, again, just from an appearance perspective, this might not be the right person to oversee, for example, the police department?
Yeah, and so, absolutely. I mean, we talked about appearance and public perception, but we also weighed heavily and made the decision upon ability and what was appropriate for the job at the time to effectively operate in that position. And from that perspective, he fit all of those bills. And what I would say as well is during that appointment and actually following that appointment is when we continued our negotiations with the state of Connecticut regarding the policing MOA, which he was involved with. And even so, saying that, the state of Connecticut even had came to a comfort level with his ability that the police department, which now we're assuming additional authority of with criminal jurisdiction, his reporting structure related to that.
I have no further questions.
Thank you.
Okay, we have several other witnesses, but I think it's 12:30. I think we ought to take a lunch break. Should we try to do it at half an hour? Is that enough? Or maybe make it 12:15? I'm sorry, make it 1:15 when we would reconvene?
1:15?
Yeah. Yeah. All right. And I think we are ready to ask Counsel Mackey to call next witnesses. Is that where we are in the process?
I believe the applicant has one more witness.
Okay, you're calling the witness, okay.
Thank you, Mr. Chairman. I just wanted to reintroduce the commission to David Nunes. David?
Good morning, Chairman Crosby, members of the commission. Director Wells, thank you for the opportunity to be here today to clarify any matters which I may for you. As I was just talking with Commissioner McHugh, this has been a long process for all of us. For me, it began in 1998 with the gayhead Wampanoags and trying to push legislation uphill up at Beacon Hill.
You should have stuck with them.
I happen to like my partners now. So I'm happy to move forward and answer any questions you may have for me this morning, or this afternoon, I should say.
Do we start with you?
You want
Certainly, I'll start out. Good afternoon, Mr. Nunes. I want to ask you a series of questions about the assignment of the interests of Ajax in the entity to the Warner Group and then the reassignment back. And we've put the original 3 or 4 pages of documents in our book. It's exhibit number 6. So
Okay.
do you?
I have it right in front of me.
Oh, okay, terrific. Let me just try to characterize what was happening there, and then I'll ask you if I got it right, just to save time. On the last 2 pages of the document are captioned "Assignment of LLC membership interest subject to repurchase right." Do you see that? Are you with me?
Yes, the one that has WG Massachusetts at the top. Is that the one? Or the...
It's the last 2 pages of exhibit number 6.
Ah, okay, yes. Execution
Yeah.
document.
Right, yeah, the execution document.
Okay.
Yeah, okay. This document is dated January 15th, correct?
That's correct.
Okay. And it is a signed assignment of the interests of Ajax Gaming Ventures, and assigned by you, assigned assignment of those interests to WG Massachusetts LLC as of January 15th, correct?
That's correct.
Okay. Who is WG Massachusetts?
That was Bill Warner's entity, which was Warner Gaming.
Okay. And the assignment provided that Ajax would assign most of its interest in this venture to the Warner Group, to WG Gaming, and then buy it all back within a 30-day period, correct?
That is correct.
Okay. And it would, in fact, the Ajax entities, after conveying the interest to the Warner Group, would buy it all back in a 30-day period for $1.
That's correct.
Okay. And as I understand it from your testimony before the Commission's investigators, you affected this assignment because at the time, January 15th, you felt that Mr. Warner's application with the Commission was complete, and also that he actually had significant gaming experience. So you thought the overall application would look a lot better if it looked like Warner had more of an interest than he actually had prior to January 15th.
Well, I think it goes a little bit further than that. I think that, those statements certainly were made by me, as I recall my testimony. But the entire group of Crossroads, talked amongst one another, and we believed that, as long as this was fully disclosed to the Commission, as it was up front, that the repurchase right was there, it was only for 30 days, and it was subject to the Commission's approval. And the documents were drafted between, Bill Warner's attorney and Bob Allen, that, if, at that time, with Bill being the only fully completed application, it made sense, a business sense to me, to do this.
But a business sense for the reason that it made the application look stronger. Correct?
At that point in time, we didn't know whether the application would be accepted or not.
But you say there was a business purpose behind it, but really the only business purpose was to make it look like Warner Gaming had a larger interest than it actually was ever going to have.
Well, Bill Warner and I, at the time, we were the majority shareholders of Crossroads. And, it was a decision, as I said, made amongst all of us that we thought it would be in the best interest of Crossroads.
Why?
Why? Because Warner's application was complete. Warner had the only background in gaming. I've been, obviously, as I said.
But if it was just a 30-day transaction and the Commission was going to know it was a 30-day transaction, what possible benefit would that give? I mean, it was meaningless.
We didn't know at the time what possible benefit it would have given.
My memory is, Mr. Chairman, if I may, was that some of the discussion was focused around, at the time, this is pre-Foxwoods, at the time, it was going to be Warner that was going to be running the gaming operation. So the structure may have changed after that point. We wanted to get the application filed so that we could, what happened next. Now, Warner had the same role as Scott did relative to finding the equity partner at that particular time. And the feeling was that Warner being the gaming partner, the structure of it was going to change when the equity partner came in. So I think the business sense at the time was thinking, since Warner is going to run operation, there will be a shift, and when the equity, there's going to be another shift. So I think that's what happened at that particular time. That's my recollection of the events.
Ajax did, in fact, buy the interest back on February 11th for $1, correct? The third page of the document, the February 15th.
February 15th, yes.
Okay. And I know your testimony is, and the record reflects, that this assignment and then assignment back was all fully disclosed to the Commission, correct? correct?
Correct.
Okay. But my question is, did you ever represent to anyone else between January 15th and February 11th that WG Gaming actually owned the 33% of Crossroads that you had assigned?
Did I
I
ever?
mean, I understand it was disclosed to the commission. Was it disclosed to anybody else?
Everybody in Crossroads knew.
Well, understanding that because they're really a party here, but, you know, did you use this in connection with marketing the project to the community, for example? The WG Gaming owned this larger share.
Well, I think if you look into, you know, at that point in time, there was, you know, a dispute that arose. So I wasn't exactly the most vocal person at that point in time.
I'm not sure I understand what you're saying.
I wasn't talking much about the project.
Okay. Was it ever represented to investors between January 15th and February 15th that WG Gaming owned this portion of the enterprise that you had assigned to them?
I don't recall that there were any discussions with investors at that point in time.
Let me draw your attention to the next exhibit, which is Bureau Exhibit number 7. And this is a letter that you wrote to the town administrator in Milford.
Right.
On April 3rd, understanding that it's written in the context of an ongoing dispute that you'd had with your partners, correct?
Okay. Yes.
Okay. Can you just describe very briefly what precipitated that letter?
You know, I guess to describe it in a succinct fashion, you know, these are complex matters, complex negotiations. A lot took place in a 24-hour period over the January 14th, January 15th period. Let's just say that the parties were at odds over the events that took place. And the two parties had seemingly found their way apart. And the town was asking about my whereabouts, since I had been the face, obviously had tied up the property and done everything with the project up until, you know, the January 15th timetable. And so they were anxious to understand where I was, and I notified them as such. And, you know, as is sometimes the case in life, you find that in a business dispute, you can find your way back to finding some common ground in which to work with. And
have you done that here?
And we settled a dispute, you know, shortly thereafter, I'd say within the next 30 to 45 days. I can't remember the exact date of the settlement. But, you know, the parties came together and worked out their differences and moved forward.
The first sentence of your letter reads, Dear Mr. Villani, I wish to take this opportunity to inform you that I will no longer be active in any negotiations with the town of Milford on behalf of Crossroads, Massachusetts, LLC, or its alleged new entity, FCX Massachusetts, LLC. And you have the word alleged in quotation marks. Tell me what you meant by that. By the word alleged.
The word alleged was I wasn't exactly clear as to what the creation, I was in the dark at the time, so there wasn't a lot of communication with me. So I didn't know what FCX Massachusetts was, so I used the word alleged.
Okay, at this point in time, Mr. Nunes, had you seen the operating agreements, the resolutions from the tribe and so forth that reflected what the structure of this entity was going to be?
Not to my knowledge was I receiving a lot of documentation.
I have no further questions.
I had a couple of questions for Mr. Nunes.
Yes, Commissioner.
I'm just trying to understand your role now, sir. I know that you are the Chief Development Officer at this point. Are you involved personally with these financial discussions regarding another business partner?
Yes.
Okay. I think the Warner matter was asked and answered. I had a question about, a follow-up question to the dispute, a financial dispute, is that correct?
It was financial and you know, a matter of authority.
Okay. And you made a statement in the report here that you were paid an additional amount for pain and anguish. Just, when I read that in the report, I thought I'd ask you to explain that statement.
I'd have to have it.
Bottom of page 84 of the report.
Page 84 of the report, okay.
It's 84 in this, David.
Oh, it is.
In your, is that your testimony? Yeah.
Okay, thanks, Bob.
That looks like his testimony, not the
That's my
report.
testimony.
Oh, I'm sorry. I thought that's what you said.
Page 84 of the report.
Oh, I'm
The
sorry.
report.
I'm sorry, David.
Well, if you looked at the history of my fundraising activities for Crossroads, I had a history of, for running the project, I was paid a sum of approximately $50,000 a month. That came to an end in January. So I called it pain and anguish because for 4 months I was suffering pain and anguish about not having to, you know, all of a sudden I've been diluted to a significant degree, and suddenly it's, okay, we might not need you anymore, you've done your job. So for me, I looked at it as pain and anguish, when it was in fact the amount of monthly management fee I was being paid all along since I began my fundraising efforts to bring partners in order to manage the process. You know, it obviously takes a great deal to handle public relations, handle the land negotiations, and handle all the other things with the town, et cetera. So that was why I coined it and gave it that phrase.
Okay. Is it fair to say, I'm maybe reading into this, and I'd like you to clarify, one of the reasons you were back with the team is the fact that the town of Milford was accustomed to dealing with you and there was uncertainty without you as part of the project?
I would say that has a good deal of truth in it.
My last question, sir, and maybe either one of you, Mr. Allen, you know, there have been so many iterations since January 15th when I dealt with you, Mr. Allen, in accepting the application, so many changes. And at this late date, there's still a major piece of it missing. And just looking at the investigation and how many changes there have been, how are we to have faith that this is now the version moving forward that will be the applicant?
Well, I will only say to you there hasn't been any changes in the recent past. There were clearly changes at the beginning, and I think David has a good point. This is a tremendously complex deal, and you have to remember on January 15th, I didn't know this gentleman to my right, and Foxwoods wasn't even in the picture here. When they come in, things change. A lot of things change. And then when the financial elements come in, sometimes there's additional changes. Now, I tend to agree with what Scott said to the commission earlier. I think we would have been in a different place had we been dealing with a city form of government. We were dealing with a town form of government, and rightfully so, the selectmen, which don't have the power of a mayor because ultimately it's town meeting that controls everything, we had to deal with them, and we had to get the community host agreement from them. So we had to get them comfortable. They had to meet Scott. They've only known David Nunes. And we had to go through this extensive process that, they put us in great shape for phase 2. We have far ahead phase 2. I wish we were as far ahead in phase 1 when we were in phase 2, but we're very far ahead on phase 2, and I think that it chilled the equity ability until we got a community host agreement. And now I think we are extremely close. I think Scott was correct. I think in a matter of days we will have something. Naturally our goal was come here today with it, but it didn't work out that way. But I'm confident that while you might see a change in the table of org, you will see a change in the table of org if it goes in one direction. If it goes in the other direction, you're going to see the same group that you see before you now. And the other reason why you won't see any changes is we don't have time to make changes. That's the reality of it. We can call a spade here. We don't have time to be bringing in any additional people here. We understand our time constraints.
Thank you.
Anybody else?
Yeah, I want to follow up. I think this is in connection to the letter, Mr. Nunes, that Attorney Mackey asked you about in the letter to the town. I believe you used the following language: I shed any faith in the project given that investors in Foxwoods have not invested the time to get to know the people of Milford. I mean, you're stepping out of this deal. It seems that language kind of goes above and beyond what you would be saying in the context of, I'm not the point person anymore, direct inquiries to Attorney Allen or someone else. That language in that letter just seemed to go above and beyond it. I mean, you're still invested in the project, you're still an investor, I guess, through Ajax and Crossroads. It seemed to be a step further than just removing yourself from being a point of contact for the town.
I think the only way I can answer that, Commissioner, is after 5 years of, pulling it all together and then being in a situation where I felt like my back was against the wall. Anger and frustration came out in my letter as opposed to maybe some smart-headedness.
The IEB report, there's what you've read, I'm sure, has some concern about your forthcomingness, the degree of your forthcomingness. They specifically mention the issue of the assertions that the financing was just around the corner, and particularly the Penn National assertion. And they characterize that you substantially misled them by substantially overstating where the Penn National deal was. How do you react to that?
If I recall the conversation, Chairman, I went in for some question. I had some questions for the director, and one of them at the time, it was concerning. We were just beginning discussions with Penn National, and there had been a meeting the week before, and although there were no actual concrete terms on the table, I could tell that by the the actual discussion of the way that the debt would be laid out and the structure would be a better structure for Crossroads than the other structure that we have been pursuing as well. So if I misstated the actual position that we were in at the time with our discussions with Penn, I apologize for that. It was really just to find out. I was really there to see if Penn was, in trouble because it had been reported in the newspaper the day before that one of the members was having a suitability issue. And so really that's what I was there to ask about. And, Director Wells reminded me at that meeting that she had sent an October 24th letter and that I, should be more concerned about those things than to be in asking other questions. So if I did mislead Director Wells, it was not my intention. I was really there to find out whether or not Penn was going to have a suitability issue or not, and it turns out they did not.
Okay.
Yeah, I have a question, Mr. Nunes. The report talks about the dispute between the partners that eventually resulted in you changing roles now to one of Chief Development Officer. How would you characterize now that relationship, especially in the context of finding that equity partnership that you need to find?
I think that everybody's working hard to, finalize this equity piece. I don't think anybody is not giving it 110% on our entire team, right down to Attorney Allen and his team. And I think that that's been everybody's primary focus. And while at the same time I've been, busy inside the town of Milford trying to win a referendum on the 19th, and as we've seen recently in a number of jurisdictions, those referendums are much harder to get than they once were. And so we've been working both fronts as hard as we possibly can.
Just, Mr. Chairman, one question. Mr. Nunes, you're described in the suitability report as being the moving force, at least originally, in the development of this project, and also as the public face of the company in terms of dealing with Milford. As you're sitting here today, and I mean today, this afternoon, what is your role, and what do you see your role going forward being?
I think it very much is a Chief Development Officer. I'm working hard within the community to raise support for the project. Which is what anybody in my role would be doing. If you're before a zoning board or anybody of that nature, and you're trying to plan a project in a town, as the Chief Development Officer, it's your job to rally support, to make sure that people are there, and also at the same time to work with others to raise funds for the project. So I very much consider my role as Chief Development Officer to be a very real role.
No further questions.
We've touched on this before, but I want to go back and just see if I can't go a little bit more deeply into the two major sort of disruptions that occurred after the application was filed. Those two major changes. January 15th, you assign your interest in Crossroads to Warner Gaming, right? The assignment gives you an option to buy it all back for $1 in 30 days. You file that assignment with the commission. In 30 days, you exercise your right to buy it back, and you get it all back for $1. The reason for doing that was what?
At the time, a decision was made amongst the partnership. And since Warner was filling the role of Foxwoods at the time, was going to be the gaming entity, et cetera. And we knew that his application was the only complete application at the time.
When you say application, are you referring to the background check, or what are you referring to? The background check forms? Is that what you're referring to?
The initial application that was due January 15th.
The background check.
The background check
Okay.
forms, okay. So, for phase one.
Yeah.
And just a decision was made to go ahead and do that.
Yeah, but the decision that was made to go ahead and do that, and by that you mean the assignment,
Yes,
was a decision that this was only going to be something that would be in place for 30 days. You knew at the end of 30 days when you did this that you might exercise your right to get it back.
well, if I recall correctly, it said at the end of 30 days,
Right,
I
you
had the
had-
right,
you
I
had the
had the
right.
right to get
That's
it back.
right.
It didn't say I had to do it at 30 days.
No, you had the option to get it back.
I would say that what precipitated my wanting to do it right at 30 days was because a dispute had evolved.
A dispute between who?
My equity partners and myself.
Your other equity
yes.
partners in Crossroads.
And, yes.
Foxwoods.
No, not
Crossroads,
Foxwoods.
the other.
No,
Yes.
the other Crossroads equity partners. And that dispute caused you to exercise your option to get your interest, the Crossroads interest, back from...
Right, because I was worried about lots of things at the time, as you could well imagine.
I can imagine a lot of things.
So Commissioner Makuta, I don't want to step on your sentence.
But can you be more concrete about what was concerning you? The reason I'm pursuing this line is that obviously, in terms of suitability, the commission is, among many other things, interested in stability and interested in the expectation that what we see presented now is what we're going to see in place for the foreseeable future. And so some of the history of changes is relevant to prediction. That's where I'm going with this. It's not just idle curiosity. So at this point, I don't understand in any concrete terms, apart from imaginings, what it was that changed between January 15th and February 15th that caused you on February 15th to exercise the option to get back that you had built into the assignment in the first place.
Again, I think the only way I can answer that, Commissioner, is that I was worried about where those shares might end up. At that point in time, a dispute had...
What Warner might do with those shares.
What Warner might do with those shares, what could have legally happened, I wanted to make sure they were back in my control.
And so some event occurred between January 15 and February 15th that raised that fear in your mind.
Yes, I think it's recognized in the, in the notes that there was a dispute that...
That's when the partner dispute took place.
The partner
All right.
dispute took place.
Okay.
Very shortly after the 15th.
Okay. Now let's jump forward to April 3rd. April 3rd, you send a letter to the town of Milford that was just quoted from a minute ago.
Right.
In which you say you're not any longer going to be the face of the project, but you also say, I have had my authority and my title stripped by my investor partners, and they wish to proceed in place of me. Can you explain in more detail what happened there?
I was sent a cease and desist letter.
And the cease and desist letter said what? In essence, I'm not asking you to
That I
quote
had
from it.
no authority to communicate with anyone on this project moving forward.
And who sent you that letter?
A law firm from Delaware that I'm not sure of.
Representing whom?
Representing my partners in Crossroads.
Oh, the other Crossroads partners?
Yes.
And what precipitated that, event?
It was the same dispute that precipitated the dispute that began on January 17th or 18th or thereabouts, lasted until the end of May.
And it was the other partners who are current partners in Crossroads
That is
who
correct.
sent you that. So you had a dispute with them that began in January, led you to get the Crossroads shares back from Warner in February, and then flared up again 2 months later in April.
It was continuous.
And was resolved, at least to the extent of putting you back as a visible part of the project in June. So that
It's thereabouts, I believe.
thereabouts,
June or May or June.
The precise dates aren't important, but it was about a 2-month flare-up then, beginning in the early April.
No, it was from January to February.
Well, I mean, another flare-up that caused, okay.
No, the
So
town, the letter to the town
Right.
commissioner, it really was because the town had wondered why I had seemingly dropped off the face of the earth.
All right, but the dispute then was one that began in early February and continued through this period until it was resolved and you came back into the picture at the end of May or beginning of June.
That's correct.
And how was it resolved? I don't want dollar figures or anything, but how was it resolved? Again, thinking about the stability of this project going forward. We're only 4 months down the road from that.
It was resolved by a meeting of the minds amongst everybody. And I have to admit that, Scott Butera, served as a great mediator in bringing people together.
All right, thank you.
If I might, Mr. Chairman, just
Yep.
one more. Mr. Nunes, you, in response to questions from Commissioner McHugh, referenced that it was this dispute that developed post-January 15th that compelled you to exercise your rights to get the shares you'd assigned back, correct? Is that correct?
To do it rather quickly.
Yes, but it was the dispute that you have referenced here that caused you to exercise your option for $1 to get that interest back, correct? Is that what your testimony
yes.
is here? That's your
Yes.
testimony? Okay. Please look at your sworn testimony, page 104. It's Bureau Exhibit 5, page 104. And you're asked by Ms. Sacco, in connection with discussion about this assignment, you'd indicated something to the effect, and I'd like you to expound upon that you did that, and that's exercise the assignment, because you thought the gaming application would be perceived better if Warner had a bigger interest. And here's your answer. This was, again, a lot of things happened between the January 13th and 15th. So in my mind, because his application was complete and Crossroads was founded by me and Warner, it was my suggestion that I said, well, why don't I assign you a bigger interest so the application will receive because you're licensed in other jurisdictions. You do have a history in the gaming business, and then I'll, at the time that my application gets completed and goes back in, I'll have the ability to acquire it back. And the discussion happened in the snap of a finger, and so it was, and a document was drafted, and we signed it, and that was really the nature of it. There was no other, rhyme or reason behind it, other than we thought that it would look better if Warner had a bigger interest in it because he was the only completed application that day. Did I read that correctly?
Yes.
Thank you.
I'm just not following how that relates to acquiring the interest back.
Well, you entered into the transaction because you thought at the time it would look better if Mr. Warner had a larger interest, but at the very beginning, your testimony reflects you intended to acquire it back, and nowhere in that sworn testimony do you reference a dispute.
But the commissioner's question was answering getting it back in 30 days, if I recall correctly.
Right.
And I don't see how that relates to the 30-day question.
I think my question is, your sworn testimony appears to reflect that you intended to buy those shares back.
Definitely.
At the time you entered into the assignment agreement.
That's correct.
And the intent was that you would do that within 30 days.
It said that after 30 days, I could acquire them back.
The right of return was after 30 days.
The right of the return was after 30 days.
And you did it on the 30th day because of the dispute that it evolved.
Right. That's how I understood it.
Okay, go ahead.
The assignment agreement, though, did require that you exercise that right within 30 days, correct?
No, after
After
30
30
days.
days.
After 30 days.
Yeah, just, if you could just look at paragraph 2 of the agreement, and I may be reading this incorrectly, and if I am, I apologize. It's Bureau Exhibit 6.
I've lost track of where it is. You don't have any idea.
Section 2 just says, at any time within 30 days after the effective date, assignor may deliver to assignee notice of its exercise of its right to repurchase the assigned membership interest.
It does say at any time within 30 days. And assignee's obligation to reconvey. Yeah, I mean, the language does say at any time within the 30 days after the effective date.
No reason for me to belabor this. I just want to make sure the record's clear that at the time you entered into the transaction on January 15th, you contemplated, as your sworn testimony reflects, that under any circumstance you intended to buy that back within a 30-day period, correct?
I'm assuming that's correct.
Okay, thank you. I have no further questions.
Anybody else? Anything? Any cross, re?
Before we wrap up?
Yeah, before we wrap up, anything else? Anybody? All right, then the applicant has an opportunity to make a closing remarks.
Thank you, Mr. Chairman. I'd just like to start by simply saying that, again, we're very appreciative of the process. I want you to know that since we've been involved, we've been working feverishly around the clock to satisfy all the requirements of what it takes to put together a great project, the last piece of which I know is the financing. But in order to have something that's attractive to a potential investor, you have to have a lot of pieces in place. The town of Milford drove us pretty hard to get the community host agreement, to get the project to the point where they were comfortable entering into a community host agreement. We've worked to do that. We've worked, very hard throughout the community to educate people on what we're trying to create, and we've put together, I think, a world-class team. And I think our project very well represents what the Commonwealth of Massachusetts is looking for in an integrated resort casino. I think that we've done something that everyone can be very proud of and will be a must-see attraction in a community that is very deserving of this type of project. So I very much understand the need to secure the remaining funding as expeditiously as possible, hopefully within days, hopefully this afternoon. I am very appreciative and respectful of Director Wells' time and understand the constraints that she's been going through and the enormous amount of work that she has, and I don't want to impose any hardship upon her. So we will do everything we can to get this last piece closed, hopefully within hours, if not days. But we understand it can be no longer.
If I could just summarize, Mr. Chairman. I think the investigators and the board did a great job fleshing out the questions. I've lived this for the last 11 years, and you've hit along all the questions. When we had some speed bumps at the middle, and I think David did a good job explaining it. But it really came down to at the last minute, some money needed to be shifted. As a result, some interest gets shifted, and David has lived this project for a very long time, and he took things personally, and maybe he put on a personal hat instead of a business hat. But when David Nunes is on this team, we are a better team. He is excellent at what he does as a chief development officer. He is excellent at what he does. These investigations can be difficult sometimes, and I'm sure people look at their transcript and say, geez, did I say that? I didn't mean to say that. But I really think today, and I really appreciate the way Chairman Butler stepped up and answered the questions the way he did. And they were tough questions, and he made some tough decisions, but he had good reasons for those tough decisions, and I think he answered very respectfully. And I do suggest to you, we have put together a good team here. If you look through the suitability, leaving the elephant of the equity out for a minute, there are really very few issues related to our suitability that wouldn't overcome the clear and convincing. I think that we have a right team here. I think one of the reasons that we got involved and we're excited to get involved is for competition in Region A. And boy, Region A is really struggling now, and we really think somewhere along the line, probably about August, we don't look at this as a license for Crossroads anymore. We look at this as a license for Milford. We've done a lot in that community. This community deserves, if they're willing to have us on next Tuesday, they deserve this license. They've really embraced us, and that has a lot to do with David Nunes. He set this table for this group, and then when Scott took over, Scott's done a wonderful job building back any trust when there was a little hiccup with the dispute. And clearly, that letter that went out was difficult. It was difficult to overcome. From a PR standpoint, how do you defend a letter that went out? And it was difficult, but Scott stood up there, we stood up there in front of Milford, and we took the punches we need to, and they're on board with us. So I think we've gained the trust in the community, and I think it's important to note, as I'll reiterate again, we've been open and honest with the commission, and I've tried to keep everybody apprised of everything. I'm extremely confident as I sit here today, and I'm not sure I could have said this yesterday, but I'm extremely confident as I sit here today that we will have the equity in place in time and prior to the Phase 2 submission. So what my request is, I'm asking the Commission to make a determination finding that the applicant, Crossroads, Massachusetts, LLC, is deemed suitable, subject to entering into an agreement with a remaining financial source, and if necessary, having any additional qualifiers vetted and found suitable prior to the Phase 2 submission date. And with that, I really thank you for the time, and again, Director Wells and Mackey and the investigators for their efforts. Thank you.
Thank you, Counsel. Thank you. With that, we will conclude this portion of the suitability proceeding. The Commission will deliberate about the matter in private and issue a written decision. We are very sensitive of the election day, and we will do everything we possibly can to get the decision out well before that. The proceeding at this point, however, does remain open. If at any point during the deliberation the Commission determines that further testimonial or documentary evidence is desirable, it may send notice of such to the applicant and provide instructions as to how to proceed. Further, all applicants, of course, have a continuing duty to provide updated information to the Commission and to the Bureau. It is now November 13th at 2:15, and we will adjourn.
Mr. Chairman, just one quick question.
Unadjourned.
Did you feel it necessary for the for a organizational chart to be resubmitted to you as kind of a post-meeting brief? I know one of the things, the way the questioning came in, we started with this wall between Foxwood, then we started to talk about the whole structure. If the board deem it necessary, I'm glad to provide you with a short little brief and probably a picture of the structure of Crossroads, if you feel it necessary. If you feel you've satisfied your concerns, then there is one in here.
Yeah, it got fuzzy for a while, but it got unfuzzy, and I
Great.
Feel all right about it.
I just wanted to make sure.
Commissioner McHugh, you?
I'm fine.
Yeah.
You can re-adjourn.
We're fine. Adjourn. Thank you.
Thank you.